So good afternoon and welcome to the 1 p.m. docket for the Board of Municipal and Zoning Appeals. My name is Becky Witt. I'm the Executive Director to the BMZA. From left to right here, you have Leland Shelton, Victor Clark, James Fields, who's the chair, and Bill Cunningham. Please silence your cell phones. If you need to have a conversation with someone, please do so out there. We have a court reporter here who's taking testimony, and it will interfere with his ability to hear if we're making too much noise. Let's see here. When it's your turn to speak, please identify yourself. You can come up here to the podium or you can sit here at the table, whichever one you prefer. And identify yourself, spell your name for the court reporter, and be sworn in to testify. If you haven't signed in already on the sign-in sheet, in front of Mr. French over on my left here, and you plan to speak today, please make sure to sign in. The board is probably going to vote today on your case, but that doesn't make their decision final. We have to issue the decision in writing in a document called the resolution, which is a process that takes several weeks, usually about 30 days. It needs to be drafted, and then usually it needs to be reviewed and approved by the board. So we will send those to you via email when they are ready for you. If you're unhappy with the outcome of your case, you can request reconsideration of the board's decision within 10 business days of the issuance of the resolution, and you also have the right to appeal the board's decision to the circuit court within 30 calendar days of the issuance of the resolution. And I'll turn it over to the chair.
Okay, I don't have much to tell you other than, we'll let you know if there's a reason we can't deliberate on your matter today. Typically, it's because we want some more information or ask that some other task be undertaken so that it can assist us in deciding the specific factors that we have to decide. But otherwise, I'm going to caution you not to take any action on your project until you receive the written decision of the board, and certainly don't commence any work in Baltimore City without pulling the proper permits. And with that, we'll just commence with the docket. And call the first case on the docket, 2013-029, 5901 Hartford Road. Ms. Hecker is here. We're doing a hearing for the purpose of discussing the scope of the substantive remand for this matter. I'm requesting conditional use approval to use the premises as a gas service station. The remand hearing itself will be scheduled later, and no testimony will be taken here. Mr. Brown, good morning, good afternoon. I said that twice now. Can't seem to get out of the morning.
Good afternoon, Chairman Fields. Good afternoon, members of the board. I am not Caroline Hecker, as you know.
No, you're not.
My colleague has deputized me to assist on behalf of the applicant, Two Farms Incorporated, in this matter.
Will do. Welcome. And Mr. Murphy?
Good afternoon. My name is John Murphy.
All right.
I'm the attorney for Hamilton Association and a number of other neighborhood associations.
All right, so why don't we approach it this way? Again, this hearing, is to set up and shape, how we're going to go about the substantive hearing that is yet to be set unless we already have a date. For the sake of time, we'd like to give you both, 20 minutes aside with a brief rebuttal. Mr. Brown on your side, maybe 10, 15 minutes, or maybe 5 minutes, and then we can do, we'll have a decision by the board. And you'll keep track of the time so that we can move along. We have a few other matters that are heavy on the docket later on, so that will commence with you, Mr. Brown.
Thank you, Chairman Fields. And for the record, Jamar Brown of Rosenberg Martin Greenberg on behalf of the applicant, Two Farms Incorporated. Just in the way of a brief background, Chairman Fields, we received Ms. Witt's email indicating that this matter had been scheduled for today for essentially a de novo merits hearing. I then responded, and Ms. Witt indicated in her email that the hearing would be, quote, without reference to any of the evidence that had been previously submitted to the board. in connection with this appeal. And so I wrote a letter responding to that email, and I believe Mr. Murphy also has written a letter in response to my letter, and that brings us here today. So I do want to thank the board for giving us an opportunity to be heard on this issue. We do think it's important. Here's the larger context for this case. The application that the board is currently considering was filed by Two Farms on January 22nd, 2013, more than 10 years ago. The first hearing before this body was held on April 2nd, 2013. And at that hearing, this board heard evidence from both Two Farms as well as testimony from various community members regarding their concerns about the proposed project. That testimony in April of 2013 focused on the alleged hazards of the current intersection. Not alleged, it's true, it is a hazardous intersection. The added traffic that the Royal Farms convenience store and gas station would generate, and the proposed street alignment that has been proposed by Two Farms, by Royal Farms in this case, to alleviate those concerns. After deliberations, after the testimony was considered, this board voted that same day to approve the application. The case was appealed. On appeal, the case was remanded back to the BMZA because the board, in that case, issued a corrected resolution after the public hearing, and the Court of Special Appeals said, board, we can't have you issuing a corrected resolution unless there's been a second public hearing. So the case was remanded back to the BMZA for the express purposes of conducting a second public hearing regarding the corrected issue in the resolution. The second hearing before the BMZA occurred on October 20th, 2015. Again, the main point of contention at that hearing was the issue involving traffic and how this development would impact traffic. The evidence included, number one, a revised site plan from Royal Farms in which Royal Farms agreed to pay for the following improvements: 39.7% more green space, the donation of a parcel of land to the Harford at the Harford Avenue and Glenmore Avenue intersection, so that to the city, for the realignment of that intersection to alleviate the traffic concerns that already exist at that intersection. Restriping of the intersection to create dedicated left turn lanes, improvements to the pedestrian crosswalks and ADA access ramps, and the replacement of the traffic signal. All of those were improvements that Royal Farms testified it would agree to perform at this intersection to alleviate any traffic concerns. Number two, the evidence included a report from the Department of Transportation that these modifications would likely result in a reduction of crashes that the site was already experiencing. Number three, there were two experts who testified on behalf of Royal Farms in 2015. Wes Guckert, a traffic expert, who said that these improvements would drastically improve operations at the intersection, create better roadway conditions at that intersection that had existed for more than 50 years. And then a second expert, Steve Warfield, who testified the same. For their part, the community also called an expert in the 2015 hearing. That expert, Mr. Gerald Neely, admitted that traffic at the intersection, quote, won't go up a whole lot as a result of the gas station and convenience store development proposed by Two Farms. And then finally, there was significant testimony from community members in opposition to the development. Nonetheless, on November 23rd, 2015, this board issued a written resolution and for the second time approved this development, approved the application. The case was again appealed. And then the Court of Special Appeals in this most recent appeal remanded the case back to the BMZA and expressly stated in its opinion that it was remanding the issue so that the board could properly consider its approval under the Schultz standards. The case is called Schultz versus Pitts. It's a 1981 case. Now, the board, the Court of Special Appeals did not order a new hearing, did not say that the BMZA needed to receive new evidence, did not say that the remand proceedings in this case needed to be conducted without reference to any of the previously adduced evidence. It would make no sense for the Court of Special Appeals to say that because the Court of Special Appeals never found any fault with the evidence that this board had received and credited twice in approving this application. But what did the Court of Special Appeals say in its remand order? It said that the board had not properly considered the Schultz standard. Now, I want to walk the members of the board through what this body determined and what Schultz said, and then what the Court of Special Appeals said about that. Here's the board's opinion, or excuse me, the board's resolution in this case. And I'm reading expressly from the Court of Special Appeals decision. In analyzing the elements contained in zoning code sections 14.2041 and 3, the board was persuaded by the fact that the community would be dealing with the same safety concerns relating to ingress and egress, light emitting signs, loitering, and increased traffic relating to the permitted as of right convenience store with or without a gas station. So the board is making the determination that in this case, Royal Farms has an as of right permission to build a convenience store at this location. What the board is simply saying is the concerns about traffic and lighting, all of those same concerns would be there with a convenience store as with a gas station. It's not going to change. So that's what the board's analysis was. What the Court of Special Appeals says, however, is rather than comparing the application for a convenience store and gas station with what would be there if it was just an as-of-right convenience store, what the board should have done in this case is, quote, should have determined whether the gas station at the proposed location would have created adverse effects above and beyond those inherently associated with gas stations elsewhere in the zone. That's it. That's it. That analysis, members of the board, can be made based on the evidence that's already before the board. Not whether or not the gas station has different impacts than a convenience store at that same site, but whether the conditional use, here the gas station, would have adverse effects above and beyond gas stations elsewhere in the zone. There is no reason why this board would need to take new evidence in order to perform that analysis, particularly here, where the application was filed more than 10 years ago, and the board has already twice approved this application based on the same evidence that it would receive in this remand. And so for those reasons, there really is no reason, nor would it be proper for this court to completely disregard the evidence that both this body has now twice relied upon in granting the application, and frankly, that the Court of Special Appeals relied upon as well. Because again, in two opinions issued by the Appellate Court of Maryland in this case, that court has essentially credited the testimony of that this board has received in affirming and approving the application here. So that's our position that, of course, it's within the board's discretion for how these proceedings should proceed, and we have no problem with that. But the idea that we would we would essentially require two farms to completely start from scratch would be, frankly, a huge waste of everybody's time and resources.
Yeah, and I don't think that's something the board would impose on two farms. This is sort of we have a record and a very lengthy record.
Exactly.
And certainly nothing precludes, on a subsequent merits hearing, nothing precludes two farms from incorporating by reference evidence that has been submitted in the record, the opinions of the prior appellate court, so that that's all ripe for, the board to consider.
That's essentially our request, Chairman Fields.
And, each party sort of, submits evidence or not at its peril, right? But there's a way, clearly, for two farms to have the board consider everything that you just mentioned that's in the record to determine the outcome, or for us to deliberate. Now, I guess, is it two farms' contention, though, that no amount of, is two farms saying that there should be no presentation of new evidence in the matter? Or is the concern certainly is the protection of the information that's already been prepared, submitted, considered, testified to, all of that is certainly right before the board. Certainly you want to protect that.
Correct.
And I don't see any reason, or I have seen any case law that would say that we can't consider any of that. So the board would intend to consider all that history to begin with. But I think if the parties feel like there's some additional information or testimony, even on the issue of whether or not a gas station at this location would have some greater impact here than it would at any other location, is your contention that there could be no possible testimony that might shed light on that question going forward?
Well, Chairman Fields, I think it's possible that there could be testimony regarding that issue. I wasn't there at the previous two hearings. I wasn't
Neither
even-
were we.
Right, exactly. None of us were. But we do have the record, and to your point, which I appreciate, we should be, and this board, more importantly, should be permitted to rely on that record. It's evidence in this case. We will certainly prepare our presentations before this body as persuasively as we can to have this board be confident it's making the right decision in approving this application. And so we certainly intend to do that. And if that means calling new witnesses in this case, then we will do that. But what I don't want, and the reason why we responded so aggressively with our letter, is for us to be precluded from relying upon any of the evidence that this board has already considered.
Yeah.
And look, things have changed, I'm sure. Some things, as Mr. Murphy acknowledges, there are now bike lanes.
And bike lanes, and bike lanes.
And lots of bike lanes, yes. Now, of course, our response to that is those bike lanes are great, but the improvements that Two Farms has already testified that it will make will enhance traffic in that area even greater than the bike lanes have. And so we are confident in our application. We're confident that the conditional use application will be granted in this case. Again, our main concern is not to be precluded from relying on evidence already adduced.
And one
sorry,
other
go ahead.
question, Mr. Brown, I don't want to interrupt you, but can you confirm that the original application that has been filed, has it been modified in any particular way?
It was modified at the 2015 iteration of this case. As I mentioned, there were revised site plans
Okay.
that were presented to this board in evidence at the 2015 hearing. It's my understanding that it has not been modified further since. But but don't hold me to that. I'll make that clearer when we actually have a full hearing on this case. But to answer your question, and I want to be very clear about this, I can't dictate what the opponents to this application are going to present.
Sure.
To the extent that they have evidence that they want to present, or frankly, to the extent that either party has evidence regarding changes that have occurred since the last time the board considered this case, of course that would be appropriate for this board to consider. But it's also equally important for the board to consider all of the evidence in support of this application that the board has already received and, as I said, credited.
Okay. Very good. Thank you, Mr. Murphy.
Thank you, Chairman Fields.
Mr. Murphy?
Thank you, Mr. Chairman.
Yes, sir.
I think, I don't know whether Mr. Cunningham was involved in the earlier case. I don't know. He was my councilman years ago, so.
He's my friend now.
One time I was arguing a case in the Court of Special Appeals, and we had a great judge by the name of Murphy. No relation, but he looked at me and he said, "Counselor," he said, "there's such a thing known as common sense." And I guess that's my main point here. It's been 8 years since the prior decision, prior hearing. I can barely remember what happened a year ago, let alone what happened 8 years ago. Since that time, there have been 2 major changes in the area. One is the zoning has changed. When the application was heard the first time, the zoning was B3 highway commercial. And it was not designed for neighborhood type commercial uses. In 2017, 2 years after the hearing, the zoning, new zoning was adopted that put it in the C2 zone that is oriented to neighborhood commercial. Now, that's the first sort of major change. The second major change is that 3 years after the hearing, the City Council adopted what was called the Complete Streets Ordinance. And this made a drastic change on Harford Road. My counselor here said that this is a hazardous intersection, and indeed it is. One of the changes, it wasn't just bike lanes that were inserted. What they also did was eliminated one entire lane in each direction. Now, so what's the significance of that? Significance is this. When Mr. Guckert testified as a traffic expert, he was testifying as to the condition as it existed in 2015 with 2 lanes in each direction. Now there's only 1 lane in each direction. It's an entirely different situation. And what's the significance of that? We're going to argue about that at the hearing. There's no doubt about that. And I'm not suggesting to the court, to the board now, that that necessarily determines it one way or the other. It's going to be an issue at the hearing, no doubt about that. But when you talk about relying upon Mr. Guckert's testimony, you have to say he was testifying on a totally different situation. He wasn't testifying about the situation where there's only one lane in each direction because of the complete streets ordinance. And I'm sure Mr. Gucker would really be the first to recognize this. It is an entirely different situation. Now, what's the further significance of this? If you let in Mr. Gucker's testimony, you're letting it in as testifying on the situation as it existed before, without the opportunity of me representing the neighborhoods to ask Mr. Gucker, well, what do you think of the change in the configuration? What do you think of the significance of the change? You don't have two streets in each direction, you just have one now. And that's what's, obviously called cross-examination. That's the very reason the first case was reversed. It's because I didn't have the opportunity to examine the change that was made in the ordinance. If you let this testimony in, you're going to be repeating the exact same mistake that was inadvertently done in the first case. Exact same thing. Because I have the right to ask Mr. Gucker, what do you think about the change in the street pattern? If you just let it in, just saying, there it is, I don't have that opportunity.
Would you have the opportunity to call an expert yourself as to what the impact of the change in the street?
I can call an expert, but the question is, do I have the opportunity to examine him as to his testimony there? No, that's the issue. I don't.
Okay, hang on one second. Do we have any subpoena power with this board?
We actually do, which I found out, and Adam Levine found out for the first time like 2 weeks ago. The chair actually has subpoena power.
Ah,
We could talk more about how that might work. It's never been exercised within Adam's memory, so.
another surprise.
The second issue, which is almost identical to the first one, is that they had one expert who testified that the proposed use was consistent with the zoning, okay? That was their testimony. And an expert testify about that, okay?
Yes, sir.
Now, in the exact standards for conditional use in your city code, one of the standards is it consistent with the zoning? That's a standard. If you allow the testimony to come in that says it's consistent with the zoning is changed. The zoning was B3, which was highway commercial. Now it's more oriented towards neighborhood commercial. So you're letting in a statement by an expert that says this zoning is fine. But the reality, Mr. Chairman, members of the board, is that the zoning has changed. He can't be saying that.
So it would be your contention that those, maybe others, but certainly what you've referenced ought to be stricken in the record, purposes of going forward in a merits hearing?
It's my contention that all the Court of Special Appeals did was it said you have to follow Schultz versus Pritz. And I'm old enough, I was personally involved in Schultz versus Pritz. Pritz was a funeral home in Carroll County, Westminster, the one to locate. And Schultz was a doctor who had a clinic. He didn't want the funeral home next to his clinic. That's what the case was all about. And all they're saying is the board has to follow the decisions of the appellate court. It didn't say that we did it based upon the prior record. It did not say that. And the normal rule, which I've cited in my letter by the Powell rule by Judge Radowski, who's one of the preeminent judges, now deceased, is that when a case is reversed, you hold a new hearing on a remand, unless it specifically says a certain restriction, like look at, the effect of a traffic light or something like that. But that doesn't have that. All this says was you got to follow Schultz versus Pritz, which every jurisdiction in the state has been following for years, and which I think the board tried to follow before. So my contention is simply hold a new hearing. What we're talking about, here's the record of the prior hearing. How in the world are you gentlemen, as distinguished as you are, going to sit down and read through 423 pages of this record, plus exhibits?
Well, I will say that it's been done before. Number
Excuse
one.
me?
It's been done before in terms of having to read and review a record. Sometime more recently, we have the benefit of videotape hearings. We probably don't have video hearings of that information in those prior hearings. But let me ask you, would the board not have the ability to take into consideration a prior expert's testimony or opinion regarding an issue of it's consistent with the code? The board recognizes and understands that the code has changed, and the board conclude or make a determination as to whether we'll accept or reject that expert's testimony, if that's what the party wants to put up, without supplementing the record.
How can you have the testimony? I mean, he's not here. All it is just written stuff. If you're going to have him, if you have Mr. Guckert here to testify, okay, I think that's basically a new hearing. I think he ought to be here, testify about the effect of the taking away a lane in each direction. It's obviously a big change. But, I have to have the right to ask Mr. Guckert. You can't have him just be on paper. I have the right to cross-examine him. That was the very reason the case was reversed the first time. I have to have that right. The same with the zoning. The zoning expert will say this is consistent with the zoning. And I'll say it's consistent with the C2. His testimony is consistent with the B3. The zoning has changed. We adopted a new zoning, as everybody knows, in 2017. And it really was changed. It's not the same. It's not just numbers and letters that have changed. So we got a fundamental right here. And I really think, Mr. Chairman, the members of the board, the easiest thing, and the most sensible thing, is just to hold a new hearing. I don't really understand what the problem is in doing that. We'll have testimony, they'll have testimony, and we'll do it. It's not that complicated a case. It's a one-day case that we had before. It's been reversed twice now. Not through any of our fault, believe me. The first time it was reversed was because Royal Farms went to the chairman after the hearing and asked that the decision be clarified.
Objection, Your Honor.
Well-
That's a misstatement of the record.
I got it right here.
Well, they didn't ask me, so.
Excuse me?
Are you talking about the very last hearing?
The first one.
Well, to be clear, the record will speak for itself, but I think I understand your point.
But the point is, 8 years, just go back to my first the judge saying to me, Mr. Murphy, there's such a thing known as common sense. Common sense tells you 8 years is a long time, and a lot happens, a lot changes in 8 years. And there's two things here that have changed very specifically, namely the zoning and the traffic. My counselor here says It's a hazardous intersection. That's what the case is all about. You can't really try the case on a traffic condition that existed 8 years ago. It's changed. That's really, I'm not trying to be difficult, Mr.
No,
Chairman.
I understand.
But I really think you really can't do it, or else we're just going to be back in the appellate court again.
And so, obviously, there's going to be a hearing on the merits. The appellant, I think in recognition of the issues that you raise, I think has the ability and prerogative to present the evidence that it wishes to present. If it presents evidence that doesn't answer the questions or addresses the findings that the board has to make, they do so at their peril, which you are well able to point out in your presentation. But I don't think anything from the appellate court has stated that we cannot consider the record or evidence that's been presented in the record. Now, the point of, or the determination of whether or not that prior evidence is irrelevant to 2023, I think that's all that's inclusive of what the board's going to have to make a determination of.
The appellate court ruled you had the right to cross-examination, Your Honor, and you know that's the case. And you can't have Mr. Guckert stand up. You can't have him say, have the counselor here say, Mr. Guckert says on page 44 that the zoning is no problem. I don't have the right to cross-examine page 44. That's the problem. It's a due process issue. I gotta have that right. You can't bring in a blank piece of paper on which is written some judgment that was made under a different zoning and different street configuration. Just not possible. Just think about it. It's not possible. And the easiest thing to do is just hold a new hearing. Both sides will come in, and we'll have, if he wants to have an expert, we'll have an expert. I can do whatever I want, and we'll have a hearing. But you can't let him come in and say, I'm going to rely on what we said back in 2015, because I don't have the right to cross-examine that.
Okay. All right. Any additional points, Mr. Murphy, or is that where you are?
I think I've exhausted your patience.
No, yeah, not at all. Oh, it's like,
No, and both
You're way
sides are
ahead.
actually, you're
You know,
within your
I
20
tell people
minutes.
that when this case got started, I was a young man.
yeah. Right. And I've been in litigations like that, and that's true.
And Mr. Cunningham, I've known him for a long time. He looks great, actually.
Yeah, he's a looker.
Yeah, but seriously, the case has been going on forever,
Understood.
and not our fault, believe me.
No, we understand that as well, and
But we're citizens groups, and they've stuck with this case. I'm just the mechanic here. They're the clients. They're the real people.
sure.
And they've stuck with this over the years. Very, very important thing for the community. I don't really want to go into what the board decided. You know, the one thing I might just end with, it's one thing to say that a gas station makes sense on a highway commercial zone.
Yes, sir.
That makes sense. But the zone is no longer highway commercial. And we cannot really rely on that, because that decision might have been perfectly sensible at the time. But that's no longer the situation. Thank you very much, Mr. Chair.
Thank you, Mr. Murphy. Mr. Brown.
Thank you, Chairman Fields. I said this at the beginning of my remarks, and I want to be crystal clear on this. Two Farms is not suggesting that there not be a hearing. Two Farms is not suggesting that witnesses be called. Again, the purpose of our written response to Ms. Witt's email was the idea, as set forth in her email, that there would be a hearing, quote, without reference to any of the previous evidence submitted in this case. That is the
idea that we are here to challenge and to make sure that we have a right, as the applicants in this case, to submit, to incorporate by reference, as Chairman Fields previously indicated, the evidence that has already been submitted to this board. Obviously, things do change. And so that brings me to the second purpose of our letter, as I stated in the letter, was let's have a hearing today so that we can define the proper scope of the remand proceedings. And yes, it is appropriate to discuss and present evidence about what has changed. And so that's exactly what I would ask the board to do, and Mr. Murphy makes a very good point. There's no reason to have this board receive evidence and testimony on conditions that are the same, on evidence that is the same. If things have changed, then that evidence should be presented and considered to this board. But there is just no point in us rehashing the same issues where there hasn't been any change. And there is plenty that hasn't changed. The intersection has not changed. That intersection is still the intersection. And so that's our request, is so that the hearing is narrowly tailored, the scope of the hearing is narrowly tailored, so that we can have a concise hearing on things that have changed, but still allow, if necessary, two farms to present evidence by way of reference to the record. Let me say one thing about this cross-examination argument that Mr. Murphy is making. This board regularly receives evidence on conditional use applications, on variance applications, by way of proffers by counsel. It happens all the time. And in fact, if you look at the board's, the Court of Special Appeals' first appellate decision in this case, it specifically references the fact that this board received evidence by way of proffer of representatives from two farms and found no fault with it whatsoever, as is the case for the vast majority of the cases that this board hears, as I understand it, that they hear evidence by way of proffer. So that's one thing. The other thing is Mr. Murphy has power to call witnesses as well. This board has the power to call witnesses as well. The idea that he was denied a right opportunity for cross-examination in the original BMZA action is just not what the Court of Special Appeals said. The Court of Special Appeals says you have to have a hearing before you change your written resolution. That's it. That's all the court said. The last point I will make is with regard to the zoning, because I suspect this will come up at the hearing. Mr. Murphy has stated several times now that the zoning has changed, and that is a material change that this board needs to consider in considering this application. That's wrong. What he fails to point out is that the transition rules under the zoning code make it clear that the analysis in this case, the consideration of the application, applies under the B3 zoning, not the current zoning. And there are two provisions that I'd like to point out. Okay. Article 32, Section 2-203J, first of all, that's one. And it says previously granted variances and conditional uses. Number one is talking about variances and conditional uses granted before June 5th, 2017, the date of Transform Baltimore. And it says, quote, all variances and conditional uses granted before June 5th, 2017, or before the effective date of any relevant amendment to this code, remain effective, and the recipient of the variance and conditional use may proceed to develop the property in accordance with the approved plans. And then Romanet 2, the very next section says, let me skip from that section down to 2-203K. 203K is specifically talking about pending applications. An application that has been submitted and considered complete before June 5th, 2017, or before the effective date of any relevant amendment to this code is governed by the code provisions in effect when the application was submitted.
that language makes very clear that when the board does ultimately consider the application, because it was submitted at the time that the B3 zoning was in effect, that's the zoning that applies, that's the operative zoning that applies for the board's consideration. So I just wanted to address those issues, but I think, as I said, we're here to talk about the scope of the hearing, and the scope, in our view, really should be limited to any condition or change or situation that has changed since the previous hearing. Otherwise, the evidence that has already been submitted to the board is proper for this board to consider on remand, particularly given the reason for the remand in the first place, which is the very simple consideration of whether or not a gas station at this location would have adverse effects above and beyond gas stations elsewhere in the zone.
Okay. And so when I previously asked if the application had been modified in any way, had the application been, and I'll just ask it again so the record's clear, modified since June 5th, 2017?
Not to my knowledge, Your Honor. Chairman Fields.
May I say something, Your Honor?
No, hold on. Is it on that issue, Mr. Murphy? Is it on that particular issue?
It is.
Go
As far as
ahead.
I'm concerned, this application was reversed. The application's no longer there.
The application.
It was reversed. It's as if it never happened. The idea that this is an approved application is just mind-boggling. This is not an approved application. It's been reversed twice,
Okay. Thank you.
explicitly.
Go ahead, Mr. Brown.
Your Honor, I'm sorry, Chairman Fields, I used to being in court. That just doesn't make any sense. This board is considering the same application that was submitted in 2013. I mean, that's readily apparent from the appeal number in this case.
There's no directive that a new
Correct.
application be filed to consider the
No.
issues?
No. Again, that's another reason why the Court of Special Appeals is saying in this case, essentially go back and consider the evidence and apply Schultz. Thank you.
Your Honor, may I just say something? Counselor continually
Hold
says,
on, I got to say, yes, you may, but it's a critical issue, and we only get one chance to do this non-substantive part of it. So let me hear you, and I'll give you a chance to respond.
Thank you.
Go ahead.
he said in his letter, and he said it right now, he said, you go back and consider the evidence and apply Schultz. It didn't say that. It never said that in the opinion. It reversed the case, reversed it.
For the purpose of applying Schultz, Chairman
It didn't
Fields, that's
say
what
go
it
back and
says.
consider the evidence. That's inserted. That's something that's not there. The normal rule when you have a reversal is you have a new trial. That's explicitly set forth in Powell and many other cases. So the normal rule should be you have a new hearing. And in addition to that, proffer is not a substitute for cross-examination. That's Law School 101.
Let me just ask you a question, Mr. Brown. On the issue of, and you've referenced it, cross-examination issue, does your client view any of the appellant rulings and remands as a directive that, as Mr. Murphy suggests, that they were not entitled to, that there was basically a violation of due process, they're not entitled, he had no ability to cross-examine, and therefore there's going to be some requirement that the appellant either strike that evidence or give the respondent an opportunity to address prior testimony in the record?
Well, the question really is, what does due process require, Chairman Fields? And the only thing that the court has said in this case is that if there's going to be a correction, a revision to the already issued written resolution by the BMZA, that it can't be rewritten or amended or revised or corrected
Without a public hearing.
without a public hearing. What Mr. Murphy is really talking about is suggesting that we have a burden to present witnesses that he himself can present. And it's really up to this board to determine whether or not it has the sufficient evidence it needs to do what the CSA said in this case, which is apply the Schultz standards. That's really the only question. I appreciate the last word on this.
No worries. Thank you. Thank you, Mr. Murphy. What is left for us to do here? I mean, we gotta form the parameters of that hearing and the scope. We don't have it, first of all, do we have a hearing date set?
We do not, and we should do that today. We have it tentatively set for the 31st of October, just because that is a day that we were trying to keep free of other things. That is Halloween. I don't know if that makes any difference to anybody. If that works for the parties, then we could set it in for that date. Otherwise, we'll have to put it in November on one of those hearings.
Discussion. Is it discussion?
Yeah, I guess we can discuss this.
Well, let me start then. I go back to his comment about common sense. If I were presenting this before a zoning board, I know there's a record, lengthy record, but not one of us have heard the testimony directly from
The appellant.
Royal Farms or the neighborhoods. And I think we deserve to hear that testimony. And I, for one, strongly suggest that we do. This matter is really important to me. And I agree with Mr. Murphy's point about the traffic engineer and his comments on a situation that's totally changed on Hartford Road. I mean, we see it every day. The situations there are different. I bet you a lot of the folks in the neighborhood leadership is different. The parents that use library and the parents that use the school are different. So they have their own perspectives that they can bring to it. And I'm not a lawyer, but, you know, I chaired the planning commission when we developed the new zoning code. I chaired the land use committee, the city council for many years, and I've been on this board. So I know a little bit about the code. And I also know that I want to hear the testimony from the beginning, full through to the end.
Now, and I would say that there's nothing precluding the appellant, and I don't think we would preclude them from bringing whatever testimony they wish to bring. And which is what I said at the beginning, you know, whatever party you present the evidence or don't present the evidence, you know, at your peril. If it's evidence that is frankly old, stale, and under the light of today doesn't meet a particular standard, you know, the board can determine that. That's the risk you run if you don't present evidence, maybe even expert testimony that says, under these conditions, a one-lane highway, one way, you know, going each way, and or that it's consistent with zoning. I know there are legal issues associated with, you know, what there's argument as to what particular code applies. But on the issue of whether or not a party can rely on evidence in the record, I don't think we've been given anything from the appellate court that says you can't consider that. But you can't, obviously, we're here to hold a hearing dealing with the Schultz standard, sort of across the board for what decision we can make and whether or not it meets the Schultz standard today. That would be helpful to hear that, you know, frankly, you know, any experts and whatever other testimony in
in light of today and the circumstances and the conditions as they exist. And the board, if we don't have new evidence, the board's gonna have to make a determination as to whether or not the record on a particular issue supports that issue. That's a risk, right? Thoughts?
I also think that, Mr. Murphy's point about cross-examination is a good one. That's really stale information that is in the record. And I think he has a right to cross-examine a traffic engineer who's considering the situations as they are today, not as they were 10 years ago.
My reading of the court order, zoning law, and the BMDA rules is that we have wide discretion here as to what evidence we hear at the rehearing. The application, as we know, is the same application. And so I think it would be very prudent for us to say, you know, the evidence from the previous hearing regarding this application can still be heard because the application, as council stated today, has not changed. They have not altered much about the application. However, conditions have changed, so maybe we say we want to hear new evidence regarding traffic conditions or impact or a new traffic study. I think we can say what evidence we want to see that will be refreshed on this topic.
It may be kind of valuable to hear new testimony in today's light to compare to how the board, which I was not a part of, I was never dreamed to be a part of, but how it could compare to how the decisions were made in the initial application, even though you'll be looking at current recommendations after the changes. I mean, that's the only thing that I would say would make sense to me. If I heard it, I can look back and revisit the fact that they said yes to this because of this. But if they were sitting here, would they say yes again?
Sure.
In other words, to draw a parallel between the two situations.
Well, you know, I agree with all of that. The prudent thing to do is present evidence on, you know, one that meets the Schultz standard, but
Which is all
yeah,
the court.
yeah, and what I think is that for purposes of whether or not old evidence can be considered, again, I don't think, based on anything that I've seen, any legal authority, that the board has to say, no, we're not going to consider
Right.
the record.
Right.
I think you always consider the record.
Yeah.
And any appeal I've ever been involved in,
Yeah, it's
up to the
evidence.
Supreme Court,
It's
you
part of
consider
evidence.
the record. That's a different issue from whether or not a party chooses to present evidence that addresses these issues today, knowing what's important, knowing what the board frankly needs to hear, because I don't think you'd want to risk.
Yeah. Yeah. I mean, in light of the road diet,
Sure.
in the complete streets, revisions to Harford Road, I don't know how much weight any
that's the
evidence
point.
regarding traffic impact
And
is
that's
going to
the point.
have in
And
the
so
record.
I think the parties know that, the appellant knows that.
Right.
And
It's
so,
your case, make it.
yeah, the appellant has they got to make that determination as to what they want to present and mitigate the risk of a conclusion
Yeah.
that old evidence in 2015 doesn't answer the question for these changed conditions.
Yeah.
So if I'm going to consider expert testimony on, what impact it's going to have, I can't, you can't.
It's plainly
Yeah,
that
you
it's a
can't
different road.
expect me to conclude that a 2-lane highway is going to be the same as a 1-lane highway with other changes. So we'll give it the weight in terms of, where we are today that it determines. Nobody's precluded from bringing any evidence in. Nobody's precluded from some, bringing a new expert in to say, or an expert to say, under these conditions. And you're right, I think there's the issue of what weight do you give evidence. I can't deny that any of this was in the record.
Yeah.
But it's for the board to determine whether or not it's relevant.
Right.
It's probative of the things we have to decide, now. And so, I mean, it's a hearing. It's an open-ended hearing.
Yeah.
You're free to present evidence. You're free
New
to
board members.
cite to
Yeah.
the record.
Have another crack at it. Should be fun.
All of that.
Plus, we have a full day set aside for,
Do we? So it's on,
Well, that was what we were planning to do, if that makes
that's what we
sense to the
should plan to
board.
do.
it could be a shorter day or a longer day, so depending on the evidence that we
Yeah.
So,
So
again,
we're on that.
but I don't think the board, should be dictating
Right.
what you gotta bring in. I think it's the very able counsel and all these and parties, so it's well able to determine what's relevant and what we ought to hear to make a decision for the conditions today. And so,
Better get to it before I
my view would be that we, obviously, with the substantive hearing, no party's gonna be precluded from, incorporating, citing to, evidence in the record. Obviously, that's the weight given to that evidence is a determination to be made by the board. Other than that, parties are free to present witnesses, present evidence, carry on with your cross-examination on any of that. And make the record that some old evidence is stale and it doesn't apply here and then should not be considered. I think that's where we are.
Does everyone agree with that, or I want to make sure I have
I'm
a
a yes.
vote?
I think that's how we should do it.
Okay, that sounds like a unanimous approval of what James just said about what the scope of the hearing will be. And to the extent that my email suggested that people wouldn't be allowed to cite to the previous record, that was never my intention, but I write a lot of emails.
I didn't
And-
ask you, I was thinking to do that while we were hearing the argument, like, wait a minute, what did it say? Because I'm not
Well, I think
privy to that.
I don't want to testify or anything. I was trying to what had previously been attempted to be scheduled by, I think, Derek right before the pandemic hit, and then by Katie at some point, but then that got postponed as well, is that they were both looking at this hearing as limited to just things that have happened since the last hearing, which seemed like a different thing than what we are planning to do now, which is to have a substantive hearing on whatever anyone wants to bring in, which could include the prior record if that's part of what people want to present. Okay,
Yeah, for what it's worth, I didn't know that's what the email meant. Had
All
I
right.
known, I would not have written my letter lightly.
all right, well, I'll try to be a little bit more
But if we're all in more enlightened,
judicious
that's
in the
fine,
future.
and
I
that's
think you ought
fair.
to send out a new email.
Okay, I'll send out a new email, I will.
And now for the scheduling of that,
Sure, does October 31st work?
for parties who want to seek,
With apologies, can I jump in on this since I'm?
certainly.
When we had this hearing last, Mr. Murphy may remember this, we were in City Hall until 11 o'clock at night on this hearing. We started
Oh.
at 1 and it took all night. So I might suggest that this be set in for a day by itself, or a day that we start earlier in the day when there's nothing else on the docket.
Oh.
Could you come closer to a microphone?
I'll come over here by my colleague.
Sure, I mean,
And we can do it on Halloween, but I know lots of people have kids and may want to be home for trick or treating, and I can't promise that that would be possible.
right, would people prefer to do, I don't think we could do the 7th, but it would have to be November 20th then, which is the week of Thanksgiving, but the Tuesday of that week.
With 5 grandkids, I'd rather not have Halloween.
I mean, we can do it,
I would prefer it later.
You'd prefer the November 20th
Yeah.
date?
I have a busy October.
Okay. Do other people have thoughts on the 20th?
Close to Thanksgiving.
I thought Mr. Murphy was saying, did you say you want to do it later than November 20th?
No.
Oh, you,
Well,
oh, that works.
November 20 is fine.
Oh, okay, that's fine with us.
But I'd prefer that to October.
Yeah.
What day of the week is
No
the 20th?
objection to that.
It's a Monday.
The Monday, is
Oh,
it?
did I, sorry. It should be a Tuesday, so I'm sorry. It's the 21st is what I meant to say, sorry.
Oh. Could we maybe do it after Thanksgiving at that point? Only because I am having house guests arrive that day.
It would be then the 5th of December.
It's fine for me.
That work for you, Mr. Murphy?
December 5th it is.
All right. So,
Would you want to start earlier in the day?
yeah, I mean, it's up to the board when you would like to start. We did start earlier for a different case, I remember.
Sure.
Which one was that?
Basically, you have to commit the whole day for
Yeah.
3 weeks in a row. 10?
10
o'clock?
a.m.
Let's get it.
Works for me.
It's probably, 10, Martin says 10 with a break for lunch. Yeah, it probably makes sense to start earlier than to be going late into the night, so, okay. We will say December 5th, 10 a.m., Royal Farms Day.
We'll have streamers inside, it'll be great.
You saying you
Chicken.
cheapskates are gonna provide lunch? Is that what I
Well,
heard?
I'll work on it. I know I've said that before, but I will try this.
All right.
All right, thank you.
Very well. Thank you.
Thank you.
Appreciate your time and your presentation. I need to go off the record for 3 minutes.
All right, we'll be off the record for 3 minutes, and then we'll come back for the rest of the 1 o'clock docket. All right, we're going to go back on the record and do just a handful more cases. Mr. Chair?
Calling case number 2023-119, 2119 West Fayette, Aaron McCray. Good afternoon, sir. Are you Mr. McCray?
No, I'm representing Mr. Lloyd.
Can you press the button on your microphone so it's green? Yeah.
All right, can you hear me now?
Yeah.
Oh, okay, I'm representing the Lloyd Group. Mr. McCray couldn't make it, so he said we just had to have somebody here.
Okay, and this is a request to use the premises as a two-dwelling unit,
Yes,
providing conservation of non-conforming density. Can we get the witness sworn, please?
So you raise your right hand. You swear or affirm under penalties of perjury that the testimony you're about to give will be the truth.
yes.
Spell your name for the record, please.
Kareem Moore, Kareem, Moore.
Thank you, sir.
Oh, James, your microphone is off.
Maybe before I turn it on, can I get your assistance here? I'm not sure what I did, but I'm looking for it. Okay, I'll hear from staff and planning.
Okay, so this request was actually submitted as a variance. However, actually, I think it was submitted as a request for residential conversion, which, as the board knows, we don't do that except in very limited circumstances. So the staff looked at the history of this property, and the zoning cards show that it was used as a two-dwelling unit multifamily in the 1950s and 60s, and we don't have any information about any kind of change of use since then. So the last legal use that we have is two dwelling units. So we put it on the docket as a request to use the premises as two dwelling units requiring confirmation of non-conforming density because we were being generous to the applicant in this case. So that's the request that's before you.
Martin French for the Baltimore City Planning Department. Planning Department was not able to locate records indicating this property did have a prior use as a multifamily and therefore was recommending disapproval. However, in view of the fact that BMZA staff has apparently determined that there are records, the department defers to the BMZA staff. Thank you.
Thank you, Mr. French. Mr. McCray, open-ended question. How many units, dwelling units are situated there at that premises?
It was two, here go photos too.
And what are those photos?
There's a photo before we got it, we did a full gut.
I'm sorry, say that again?
We did a full gut of the property. Before we did a gut, we took pictures.
When did you do the full gut on the property?
Maybe about 6 months ago. It was a big hole in the roof. You can probably see that on the photos as well. There was a big hole in the roof, so there was a hole in the second floor as well. So we fixed the roof, we fixed the flooring, and we just pretty much just need approval so we can go ahead and finish the house.
Okay. Ms. Witt, I'll wait till you get to a microphone. The records that staff had access to that unfortunately the planning department didn't, those records consist of what that show us the
The zoning
history?
cards.
The zoning cards,
So
okay.
I think they probably are in the file that you have, a scan of the zoning cards, but there is a record that shows that it was used as two dwelling units in the 50s and 60s, and then probably at some point, maybe in the 70s or 80s, became vacant and has
Yeah,
been
but it's
vacant.
been vacant since we bought it.
It seems like it's probably been vacant for quite a long time.
Yeah, it's been about 15 years.
And there's never, in the records that we have, there was no conversion back to single family at any point.
Okay, thank you. And sir, do you have any information that conflicts with the history that staff was able to generate?
Nah, just the pictures that we have is, just confirming that it was, pretty much. And we like to keep it the same way.
All right. That was the other question. You're intending to utilize it as two dwelling units going forward?
Yes, sir. Yep, we'll keep it the same way.
Okay. Any questions for the applicant?
No,
All right. Thank you, sir. Appreciate it. Based on the record before us, this was presented to us as two dwelling units requiring confirmation of non-conforming density. We do have in the record zoning cards that show prior use as a two dwelling unit from the 1950s and 60s, and no information since then, and critically, no information evidencing a conversion to single family or otherwise. So I'm a yes to this application.
yes.
I'm a yes.
Yes.
Thank you.
All right, thank you.
All right. Case number 2023-120, 1511 Ashburton Street. Welcome, Ms. Tilden.
Hello.
How are you?
I'm doing well. How are you?
Good, thank you. You're here on this particular property requesting to use the premises as a community center, requiring conditional use and off-street parking variance approval.
Yes, that
All
is
right.
correct. Just gonna provide this information for you.
Thank you.
Thank you.
And I'll hear from staff and planning.
Okay, so there's a conditional use being requested here, community center, and a variance also needed here for off-street parking. And I can be corrected if these numbers are incorrect, but I believe it's 88 spaces are required, 56 are provided or proposed, so it'd be a 32 space off-street parking variance requested for this appeal.
Hold on one second, Mr. French. you have a witness here. Do you expect testimony from the gentleman?
Yes, I
Okay.
do.
I'm sorry. Could we get the witness sworn, please?
Sir, you raise your right hand. You swear or affirm under the penalties of perjury that the testimony about to give is the truth.
I do.
I need to state and spell your name for the record.
Mujahid Muhammad, M-U-J-A-H-I-D, last name M-U-H-A-M-M-A-D.
And hopefully Mr. Muhammad will not need to speak, just in case.
All right. No worries. Mr. French, go ahead.
Okay. Planning Department has reviewed this application, notes this building is a former public school. It is in fact currently property of the mayor and city council. It was last authorized for that use, educational facility, primary or secondary. The now vacant building would be reused for various community-oriented purposes, which are being developed in consultation with the surrounding community. The department recommends approval of the application. Thank you.
Thank you, Mr. French.
All
What was
right.
yours, Ms. Tilden?
Thanks so much. So just for the record, Drew Tilden of Rosenberg Martin Greenberg here on behalf of the applicant. I am joined, of course, by Mr. Muhammad, a representative from the applicant. With the chair's permission, I would like to proceed by proffer.
Absolutely.
Fantastic, thanks so much. So as mentioned by Mr. French and Ms. Witt, this is an application requesting conditional use approval to operate a community center and also variance approval from the code's off-street parking requirements to provide 56 spaces in lieu of the 88 that are required under the code. The property is located on Ashburton Street at the very end of the street. It's in the Northwest Community Action neighborhood. The parcels to the properties north and east are improved by single-family dwellings, and to the west is Rosemont Elementary School and an office building. I've included an aerial image as well as street view images in the file for the board's reference. On March, the property was most recently operated as the Dr. Lily M. Jackson Elementary School, but it has been vacant for some time. On March 2nd, 2022, the Board of Estimates authorized the execution of an LDA to sell the property to the applicant. Shortly thereafter, the applicant raised the vacant school building in furtherance of the subject project. Just brief background on the applicant, Keys and Powers. The organization is a nonprofit community advocacy and nonverbal mental health treatment organization. They provide services for community members of all ages, and the programming is designed to heal communities from the ground up by uplifting those who are most at need. Keys has a number of programs across the city right now, including a community health center, senior centers, a youth services bureau, and a variation of non-traditional therapy. They use music therapy, art therapy, culinary therapy, photography therapy, and horticulture therapy, just to name a few. For the site, the applicant proposes to construct a 25,971 square foot structure. On the property, it will operate as the Keys Community Healing Village Center. The building itself is going to include offices, event space, a kitchen, a media lab, meeting spaces, and a gymnasium. The applicant proposes to construct a substantial outdoor amenity area on the westernmost portion of the property that was previously used for the elementary school's playground, and they also propose to include a walking trail on the southernmost portion of the property. I've included a floor plan and a site plan in the file that I provided for the board's reference. As I mentioned, the facility is going to provide 56 off-street parking spaces at the front and the rear of the building. It's going to take a multi-system approach to community healing, so it's going to target the individual and the family and the community in various elements. The center is going to be operational for 24 hours a day, 7 days per week, but the overnight offerings are going to be for emergent mental health issues. They're going to employ a total of 100 staff members that's going to be staggered over the course of various shifts. So of course, not all 100 staff members will ever be on site at once. The project has engaged in substantial community engagement with the Alliance of Rosemont Community Organizations, ARCO, and they have actually provided input on the center's design and operation. Additionally, the City of Baltimore has provided $1 million for the project, the State of Maryland $3 million, and Coppin State University has contributed $1.25 million. As I mentioned, we are requesting conditional use approval for the community center use as well as variance relief from the code's off-street parking requirements. In the interest of time, I will go through just the conditional use requirements first. As the board knows, in order to approve a conditional use application, there are several considerations the board must take into account. I am going to skip to the Schultz and Pritt standards. Pardon. move through. So first and foremost, the establishment and location, construction, maintenance, or operation of the use is not going to be detrimental to or endanger the public health, security, general welfare, or morals. No element of the center is going to be detrimental, and the applicant has actually obtained buy-in from various government agencies, elected officials, and community stakeholders. The use is not precluded by law, and there is no urban renewal plan in the area. The authorization is not contrary to the public interest as demonstrated by the support from the city, state, Coppin, and ARCO. And the authorization is in harmony with the purpose and intent of the code as it fulfills the code's stated intent to promote the quality of life for current and future generations by providing unique amenities, including a media lab and vital social services to Baltimore City residents. Moving on to the uniqueness standard, moving on to the variance standards required for the off-street parking variance. The property is unique in that it is abnormally shaped. Again, I refer you to the aerial image as well as the block plat that I've included. There is a large chunk that is outside of the eastern portion of the property because there are several residential properties. And also the property extends farther west on the northern half than the southern half. Additionally, it was most recently developed for use as a school, and it currently actually has 36 parking spaces in the front of the property, and there's a green space on the southern and western portion of the lot. In terms of practical difficulty, it also meets the McLean standards. Preliminarily, the applicant proposes to maintain the existing 36 space lot and add an additional 20 off-street parking spaces. So to require the applicant to provide 32 more spaces would result in a practical difficulty, taking into consideration the existing structure and the green space, which it is in the public interest to maintain. The variance would do substantial justice to both the applicant and other property owners, taking into account the green space. Most importantly, it's going to support the interests of surrounding property owners by providing additional public green space. No lesser relaxation of the standards would suffice, as that would result in substantial elimination of green space. And the relief would be consistent with the spirit and intent of the code. With the spirit and intent of the code, and the welfare would be secured. It is unlikely that the majority of visitors are going to travel via car to the facility, so the grant of this variance will not have any negative impact. As the board knows, there are several other considerations. I'll run through them briefly. I know that you all have been sitting here for a long time. There are no other properties in the city that are similarly situated given the property's shape and prior use. The unnecessary hardship is caused by the property's uniqueness as discussed above and the application of the code's parking requirements to the property. The purpose of the variance is to facilitate the historically vacant property's redevelopment for the community center use, and it is not to increase the income potential of the property. The variance will not be injurious to the use and enjoyment of other property in the immediate vicinity or substantially diminish or impair the property values in the neighborhood as demonstrated by the community support, as well as the city, state, and Coppin State University's support. It is in harmony with the purpose and intent of the code as discussed earlier in my conditional use analysis. The property is not located within an urban renewal area, nor is it located in a historic district. Furthermore, it supports the live element of the master plan, which is to build human and social capital by strengthening neighborhoods. And finally, the support of ARCO, the city, the state, and Coppin State University demonstrate the authorization is not contrary to public interest. For these reasons, we respectfully request the board's approval of the subject application.
Okay. Any questions for the applicant?
No.
Okay. Well, we're going to truncate this even more. With regard to the conditional use standards, with my fellow board members' permission, I'm going to incorporate, I'm a yes, and the basis for that would be an incorporation of the presentation of Ms. Tilden, including the written materials presented as to the conditional use standards, and not finding any other information in the record contrary to that presentation. I believe meets the standards for conditional use, so I'm a yes as conditional use.
Yes.
Also, yes, as conditional use.
And
Yes, conditional use.
Could you turn your microphone on, please?
Oh. Oh, yes.
Thank you so much.
Similarly, with regard to the variance request, parking variance, have to incorporate the presentation of Ms. Tilden and the written materials, which walk through each of the required findings for the approval of a variance. In this case, and not having seen any evidence in the record to the contrary of that presentation, I will accept that presentation, and I'm a yes as to the variance.
Let me ask,
Also, yes.
Yes.
Thank you so much.
Fantastic.
Good luck.
Thank you so much.
Looks like a wonderful project. Thank you. Calling case number 2023-123, 2617 Linwood Road. Danielle Moy, or Moye? Moy. Come on, ma'am. Welcome. And Moy is the correct pronunciation?
Yes, that's fine.
All right. And this is a request to use as a single-family dwelling, use the premises as a single-family dwelling and daycare center up to 12 children requiring conditional use approval, correct?
Yes.
All right. Let's get the witness sworn, please.
Raise your right hand, please. You swear or affirm on the county's perjury the testimony you're about to give the truth.
Yes.
And I have your name, so we're good to stop.
Danielle Moy, DANIELLEMOYE.
Thank you.
I'll hear from staff and planning.
Okay, so just one conditional use being requested here, daycare center child, and the board may want to ask its usual questions about pickup and drop off and exterior lighting. I think those are the main questions that the board usually asks.
Planning Department has reviewed this application, notes that this is a request to serve 12 children on site. The only department's concern has to do with drop-off and pickup, as mentioned by BMZA staff, along Linwood Road. The property has at least 50 feet of street frontage, not counting its driveway. And therefore, the department recommends the applicant contact the Department of Transportation and the Parking Authority of Baltimore City concerning possible creation of a passenger loading zone in front of the house. And therefore, the department recommends approval of the application subject to that condition. Thank you.
Okay. Ms. Moy, you agree to contact Department of Transportation with regard to pickup and drop off safety
Yes.
issues? Okay. Is this a new daycare center
No, I have a family daycare already.
at that location?
Yes. There's just an increase in child.
Okay, so you have it presently up to, what, 6 children?
8.
8?
Yes.
All right.
Just for the board's information, in most residential areas, daycare home is up to 8 children, and that's permitted by right.
Okay.
But if they want to go above 8, then they have to have daycare center, which is above 8. So that's why you often see going from 8 to 12.
Right. Yes.
And presently, where are folks dropping off and picking up their children?
In front of my door right now, I have a long driveway. So all of my cars in the driveway, my neighbor also is no longer there. His house caught on fire. And that's right next door. And across the street, my neighbor allows us to park if we needed to park any of my cars there. Because he's gone during the winter. So we normally park across the street, one of my cars or if need be. But we have driveway space well enough.
Okay, does a driveway suffice in and of itself? Because if your neighbor decides to rebuild a house that had the fire and your
Oh,
other
yeah,
neighbor
we have
decides
enough
to change
space,
his
yes.
mind?
My driveway is long enough for 4 or 5 cars. And we're way over that. That's without even using any space in front of the house or anything like that.
Okay. Okay. What are the hours of the daycare proposed?
Right now, or the one,
Or what you plan to operate?
6 to midnight,
6 to midnight.
yes.
Do you currently, what are your current hours?
6 to midnight.
Okay. And if you don't mind, what is the circumstance of the lengthier hours to midnight? That seems a little bit,
Well, it's
unusual.
for people who work at night, mostly nurses and doctors, helping them out. And like now we get a lot of people with Amazon. So Amazon has this crazy flex schedule. So it's really there to help out people who can't and don't have care for nighttime. A lot of the daycares closed during COVID. So I was one of the ones that were open, was essential worker. And I accumulated a lot of, I had a lot of nurses, and now as far as polices and things like that, people who have schedules around the clock.
Sure. Okay, good. Got it. And there are staff in addition, you're part of the staff, I take it?
Yes, sir.
Do you have additional staff as well?
Well, we can't do additional staff until we get approved.
Right, you'll have
But I
additional
have,
staff.
I have them in the works already, yes.
Is there any reason that you're aware of why, it's an odd question to ask, but I'm asking for a reason.
Okay.
Why, any information that you have that this operation of the proposed new daycare would be detrimental to the community in any way?
No,
Do you believe it would be beneficial to the community?
yes.
All right. Any questions for the applicant?
No.
Okay. Thank you, Ms. Moy. So we're here on this particular matter on a conditional use for a daycare. The applicant has agreed to check with Department of Transportation with regard to any suggestions or requirements regarding changes or modifications to drop off and pick up. But the applicant did advise that there's sufficient area and safe area for drop off and pick up. I've seen no evidence in the record that the operation of the daycare would be detrimental to or endanger the public health, safety, or welfare. It's certainly not precluded by any other law. The authorization for the conditional use would not be contrary to the public interest, and I believe it also would be in harmony with the purpose and intent of the code. I'm a yes.
I'm a yes.
Also a
Yes.
yes.
Thank you,
Thank
ma'am.
you.
Good luck.
Thank you.
Okay, calling case number 2023-130, 2232 East Monument. Ms. Hecker, come on up.
Good afternoon, Mr. Chairman. For the record, Caroline Hecker, Rosenberg, Martin, Greenberg, on behalf of the applicant. I have a few folders with just a handful of exhibits for you.
All right,
This should
terrific.
be relatively straightforward.
Thank you.
Thank you so much.
I have with me James Brothers, Dr. Walter Toller, and Nicole Queen.
Okay.
With your permission, I'll proceed by way of a proffer, and then they can certainly answer any questions that the
All
board
right.
may have.
And let me just confirm, that this is a request to use the premises as a healthcare clinic with methadone treatment services requiring conditional use approval.
That's correct.
All right. If we could just have all the witnesses sworn.
Raise your right hand, please. Do you swear or affirm the perjury testimony about giving the truth? And I need you to spell and state your names for the record.
James Brothers, James, B-R-O-T-H-E-R. Walter Toller, W-A-L-T-E-R, T-O-L-L-E-R.
And Nicole Queen, Nicole Queen.
Thank you.
Thank you. Hear from staff and planning.
All right, so there's a conditional use requested here is for a healthcare clinic with methadone treatment services. The existing use is also a healthcare clinic, so we're all curious to find out why we needed to have this hearing at all, but we're excited to find out. That's it from me.
Thank you.
Thank you. Planning Department has reviewed this application, notes this property is in the Middle East Urban Renewal Plan area. The Urban Renewal Plan does not prohibit or further restrict the proposed use. The plan does include in its Appendix B a designation of this property as part of the East Monument Street business area for which exterior rehabilitation standards are provided. And the applicant is encouraged to consult Appendix B of the plan in advance of designing specific improvements or alterations to the existing facade of the property. Beyond that, the department is recommending that approval of this application be subject to the condition that all improvements or alterations to the existing structure are completed or installed in accordance with plans to be approved by the Department of Planning. Thank you.
All right, Ms. Hecker, is that condition agreeable to your client?
It is, but for the record, we're not planning any exterior improvements at all, so.
Understood. All right, you
Well,
may proceed.
To cut to the chase, I know Ms. Wood is dying with excitement over here. If this sounds familiar to you all, it should. This matter was in front of the board a couple of years ago for approval of the healthcare clinic, and the board approved the healthcare clinic in 2021, and there's a copy in the file of the board's original approval. And the operation has been very successful. They've been in business now for a little over a year, and they provide a suite of mental health services to the community. They've developed great rapport with the community. They'd like to add methadone treatment services. And as Ms. Wood correctly notes, it's the same use under the zoning code. But because it was not part of our original application, we wanted, in the interest of full transparency, to come back to the board and make sure everybody understands that we're adding methadone treatment. We have not heard any objection from anybody about it. We think it's something that, unfortunately is needed in the community, and we hope to be able to provide this additional service. It doesn't change any of the conditional use standards that the board already found in approving the original application. The use operates until 5:00 p.m., so it's not it's normal business hours. They're not open late into the evenings. They have a handful of staff right now. They'll be adding a couple of staff members to accommodate what they expect will be an increase in patients. And they do intend to have additional security on site to handle any overflow traffic of folks coming in and out. But for all of the reasons that the board originally approved the application, it should be approved again. Again, it is the same use technically under the zoning code. And to be perfectly honest, we got the same reaction from the zoning office when we filed the application. Hey, wasn't this already approved? Why are we having another hearing? But in the interest of full transparency, we will be applying for additional state licenses in order to provide this service. And we need the zoning approval to specifically specify that it does include the dispensation of methadone. So yeah, I can go through the conditional use standards. The property is about 3,000 square feet. The building itself is about 9,000 square feet. The use exists, the existing use operates only on the first floor, and that will continue going forward. We're not planning to expand the use. There's not anticipated to be any change in traffic patterns or off-street parking and loading. We're located in the C1 zoning district, so there's no parking requirement. Most of the clients walk or take public transportation. In terms of the nature of the surrounding area, it's a commercial corridor. We don't expect the addition of the methadone treatment to impact existing uses. There are, because it is on a commercial corridor, there aren't any residents in the immediate vicinity. They're a little bit further back, a few blocks away. The property is accessible for emergency vehicles, and again, this change won't have any impact on the accessibility of the property for emergency vehicles, nor will it impact light and air to the premises or the type and location of public utilities, access roads, drainage, cultural or historic landmarks, any of these things that the board has considered already and is required to consider in modifying the conditional use. As Mr. French noted, it's located within the Middle East urban renewal area, which does not prohibit this use. In fact, oddly, it calls for C2 uses in this on this site, even though the site is zoned C1 and in the C2 district, the use would be permitted by right. So that's a little oddity about the urban renewal plan that you can file away for the future. In short, the establishment, location, construction, maintenance, and operation of the conditional use will not be detrimental to or endanger public health, security, or general welfare or morals. Again, this is something that they've had a great relationship with the community over the last year. They want to be able to expand the suite of services that they offer, and it is the same use that technically under the zoning code that they currently have approved.
Quick question. Has the operator contacted the community regarding the addition of methadone
There's
services?
not a terribly well-organized community in the immediate vicinity. They have notified them, but we haven't had any opposition. We haven't had any real, there's not anybody really to sit down with.
Okay. Go ahead. I'm sorry to interrupt. Is that it?
For all of those reasons, we would encourage the board to approve the application. I'm happy to answer any questions that you may have.
I will say this, that generally on our end, we usually have more a lot of issues with methadone clinics trying to open up under office uses or which are permitted by right in a lot of places, and then they start providing methadone services, which are obviously very needed, but I just have never seen a methadone clinic be so upfront about their desire to provide this kind of service, so I appreciate
So
that.
we're clear.
Right, full transparency, that's what we want.
That is not
so.
what I have experienced in the past, so I appreciate that.
Sure. Okay, any questions for the applicant?
No, none.
No.
All right. Thank you.
Thank you.
For the presentation. Again, we're here on conditional use. I will accept the presentation of Ms. Hecker in terms of the standards for conditional use and her litany of how they have been met. I don't see any evidence in the record to the contrary. Also going to incorporate, in terms of the board's information, the written outline presented by Ms. Hecker, which demonstrates that the applicant has met the standards for conditional use. Tell me yes.
Yes.
I'm also a yes.
Yes.
Thank you all.
Thank you. Yes, we go off to 3.
Right, so our next case is scheduled at 3 PM, so we'll be back then.
Very well, thank you.
I'm sure he's on his way.
How you doing with the church?
Say again?
How you doing, your brother-in-law with the church?
Yeah, they're coming along. You know, they're getting the message with regard to some of the other neighbors and not, blocking their driveways and whatnot. And so they're okay. They're okay. Yeah, they're respectful of what I put up and they kind of look out. So, and it's working out for them. Their congregation is continuing to grow. You just have to plan for Sunday. It's going to be, if you plan on having anybody over, letting them know. But I use my neighbor's driveway across the street as well. She goes out once in the morning to the farmer's market, and she's in the rest of the day.
Is it mostly, Northeast Baltimore, or is the congregation mostly Northeast Baltimore?
Actually, my brother-in-law's new wife she had a church in West Baltimore, and so I think a lot of folks come from there.
Wait a minute, your brother-in-law's
Yeah,
new wife?
my sister passed away.
Oh.
Just say,
You got me there for a second.
yeah. And so they combined their congregations. His was in Dundalk. Yeah, he had a church in Dundalk of all places, but it's now a big building in the community. And they came from all over because he's from Harford County. And so they traveled there, and they figured they'd meet midway, so we were looking for a place, Northeast Baltimore. I have no comment.
Did you ever hear about Dundalk got its name?
No.
Well, second group of immigrants came in on a boat from Mexico, and the immigrants standing on the shore, and went, Dundalk, Dundalk.
And he did it anyway. Here we go.
Dundalk has been an object of derision.
Oh, man. It is.
Last year it was here, right?
I don't know, no.
It was in City Hall.
It was City
It was a
Hall?
long time ago.
Yeah.
Well, somebody even need to drop a dime to City Hall if they're answering the phone today.
You want me to try calling Joe directly?
Yeah, he's usually on point.
I know.
You guys are on there for this one.
What's that?
In 2022, most of y'all on the board.
Yes, yeah. I think all of us were.
So it gives me a chance just to hear the experts.
Yeah.
I don't think I have a cell phone number.
I guess if anybody was in your office or hanging by the front door of it, nobody's there.
Want me to call him? Want me to call him?
Oh, you got his number?
Yeah.
Uh,
Everybody's number.
yeah, sure.
You dope. All right, see ya.
He was at City Hall?
He was at City Hall, he's on the elevator.
Oh, did you call him too?
Yeah.
We all called.
He didn't even give me a chance to call him an idiot.
I think so, yeah.
His client posted the sign.
Is it okay if I get situated up here?
Sure.
Okay, Mr. French. Turn it on yet. Okay. Just remember to turn it on when you're ready.
Sorry, everybody.
No problem.
All right. Here now.
Old habits die hard, sorry.
No problem. We're good.
All right, so we're back on the record. 307.
Okay, calling case number 2017-073, 5715 Roland Avenue. Appellant Joseph Woolman here, and this is a remand of BMZ, case number 2017-073 regarding revocation appeal of permit number use 2016-03740 and setback variance per section 4-107B2. Pretty much right. Okay. And so we'll hear this matter, on the remand, and welcome, who starts? I guess it's,
I think Mr. Woolman.
Protestants, appellants, I guess that's us, perhaps, yeah.
I guess technically back in 2017, it was Mr. Naylor's variance request, so I guess we're really technically the applicant at this,
yeah.
even though it was
yeah, you're
all
the
those years
applicant.
ago.
You're the applicant, so that, and I guess you have the burden of demonstrating the elements of the variance, including specifically the practical difficulty. And
On
so-
the remand, correct?
Right, on the remand, so.
So if it would
I
please you,
think-
Mr. Chairman,
catch my breath running across the street
Sure,
again. I
sure.
apologize to Mr. McCann and everybody else for running a couple minutes late. Well, as I mentioned, this goes back to 2017. It's got quite the history. I did file a memorandum on Friday, which I believe the board members hopefully have a copy of, and I sent a copy to Mr. McCann. Before I get to the contents of the memorandum, I also received from Ms. Witt, and I appreciate it, I guess a couple of emails were sent to the board from both Ms. Taylor and then another neighbor yesterday. And I found the second email to the board quite interesting, and I think it kind of frames the entire matter in one sentence. And it's ironically an email from someone who's opposed to where Mr. Naylor built the house. And I'll just read from it. If you don't have a copy of it, I have a copy of it. September 18th, 2023, City of Baltimore, BMZA, zoning hearing for 5715 Roland Avenue. As a neighbor in the North Roland Park community, I oppose the current position of the house located at 5715 Roland Avenue and support it being moved back to a proper setback if it can be performed by reasonable means. And he just phrased the entire crux of this case in that one sentence, if it can be performed by reasonable means. Obviously, our position is it can't be performed by reasonable means. And the reason it can't be performed by reasonable means is there is a practical difficulty in moving the house back 10 feet. And that's what this case is about. It's about 10 feet. It's about 10 feet of setback. It's set back 30 feet from the street now. Assuming arguendo that Mr. McCann persuades you to rule against us, what they're requesting is that the house be moved back 10 feet. And Mr. McCann submitted exhibits over the years of this matter with green arrows drawn on moving the house that was built back 10 feet, and you should be able to do that. But you can't, and you can't because there's a practical difficulty, and that practical difficulty is the location of the landscape infiltration facility, which I learned way more about than I ever want to learn about anything ever again. And on its second hearing on remand, the board heard expert testimony from both sides about the location of that landscape infiltration facility. And it was that same landscape infiltration facility and where it needed to go that the experts testified to in the last hearing before the board. And there's ample evidence and testimony in the record from both experts, and the board, in our opinion, obviously properly ruled in favor of what our expert had to say about the fact that you couldn't put this landscape infiltration facility anywhere else reasonably. You could put a cistern on the roof of the house, I guess, if you wanted, but that's just not reasonable. So, I thank Mr. Jeremy Olt for the email because it kind of frames the case pretty well. I would be remiss if I didn't mention something about Ms. Taylor's email to the board. And while it may not be germane to the legal issues, my client was quite upset, and I wouldn't be doing my job if I didn't at least briefly address it. She wrote in the last paragraph, "The owner of the home at 5715 Roland Avenue, Mr. Guy Naylor, is not a resident of our neighborhood. He is a builder, real estate developer who moved out several years ago. At prior hearings, we've rarely or never seen the engineer, the architect, nor Mr. Naylor. This is a builder developer trying to make a profit with a poorly planned project at the expense of our historic neighborhood." Mr. Naylor is not a developer. I've been representing developers in front of this board for 20 years. Mr. Naylor is a father. He built this house because his kids were going to school down the street. He lived way out in the country and wanted to live close to the school to go to sporting events and other events, and that's why he built the house. He moved out when his kids graduated from that school down the street. He's not a developer. When I read this letter to him, he was incensed and asked that I at least mention that to the board. I recognize that's not germane to the legal issues, but I need to represent my client as he saw fit for me to do. I'd like to briefly go through my memorandum and highlight some points within it that I think frame the case, recite various portions of the record, and there's a considerable record. When you talk about a case that goes back to 2017, we've got a lot of testimony, we've got a lot of exhibits, and a lot of history, and the board has, in my mind, done its job prior to today. It's issued 2 resolutions on remand. One was really focused on the law in response to the Court of Special Appeals, and the other was more focused on the facts in response to Circuit Court Judge Hahn. I think if you look at both those remands together, you can reconcile both the law and the facts in favor of Mr. Naylor. I'm not particularly sure why Judge Addis did not do that. When he focused at the end of his remand order, he only focused on the second of the board's remand orders. I think it was his job, frankly. I know we're not here to appeal Judge Addis, but I think it was his job to look at the entire record and look at both remand resolutions that you, the board, have issued in the past. And I think if you look at both of them in their entirety, then the case can be resolved on the record. But here we are, Judge Addis wanted, in my mind, I think Judge Addis wants you to do that. He wants you to reconcile those two previous resolutions and issue a comprehensive resolution that addresses very thoroughly the law and the findings of fact that you made after the last hearing we had the experts testify. And with that in mind, on the first page of my memo, there's a footnote. I think it's extremely important to note the Circuit Court's second remand, Judge Addis's remand, included the following. To be clear, though, this court is not necessarily remanding this case because it finds more testimony needs to be taken. And obviously, I've kind of already made that argument. There's been ample testimony, and Judge Addis agreed. Regarding the case and the procedural history, Judge Addis laid it all out very thoroughly. We adopted that in our memorandum. But we do want to emphasize the fact that the particular practical difficulty caused by the property, and in my memo, I highlighted property because it's the practical difficulty caused by the unique characteristics of the property. And that's a direct quote from the Court of Special Appeals remand order. It's the unique characteristics of the property, not of the design of the house or anything like that. It's what is unique about this property that causes practical difficulty. And you heard ample expert testimony that that was the forest conservation easement that's to the rear, and then the need to put the landscape infiltration facility at the rear as well because of the way water flows, and there's a whole litany of expert testimony that you've already ruled upon regarding why it needed to go where it needed to go. That pushed the building envelope that was available to my client forward, hence the need for the variance for the setback. So I think it's important to note that in the Court of Special Appeals original remand. And that's really what we're kind of all the way back here on for a third time. This all originated when the Court of Special Appeals remanded this back to the board way back when it did. And at the time, all the Court of Special Appeals asked was that the board must articulate the particular practical difficulty caused by the property. Again, the property's unique physical characteristics, and that's on page 19 of the Court of Special Appeals order. Maybe more importantly, the court also was really careful to point out that no errors in the board's finding with respect to all the requirements of the zoning code were found. They didn't find any error by the board. They just wanted the board to go a little bit further and, in our mind, just identify what that practical difficulty was. And the Court of Special Appeals actually hinted at what that was in its decision when it mentioned that it might be this landscape infiltration facility, but the board didn't fully articulate that. So when we first came back to you all, and that's when I first got involved in the case, we asked the board to articulate that finding and that practical difficulty. And the board did that. Judge Hong then heard the case on appeal as Ms. Taylor appealed the case again. And she pointed out, Judge Hong did, when she first had the case, that in 2017, the BMZA ruled that with respect to section 15219, which is the variance standards, the board found that one, the property was unique because of the aforementioned easements, and two, practical difficulty was not created by the respondent, but rather from the property's uniquely inherent physical limitations. And that's in Judge Hong's order. Further, she wrote, the board finds that the unique characteristics of the property, which predated the Naylor's purchase, created the practical difficulty in designing a home that met the needs of the applicant, was in harmony with the other homes in the neighborhood, and adhered to the strict application of the setback restrictions. And that's page 4 of Judge Hong's order. But then even more importantly, she addressed what the Court of Special Appeals identified to be the McLean factors. And that's something that the board may consider. It's not a requirement, but as Judge Addis pointed out, you may consider these additional McLean factors. And Judge Hong wrote, while the board did not specifically identify the McLean factors in its resolution, it did address each factor. First, it found that the restrictions and covenants discussed supra would render conformity to the 40-yard setback unnecessarily burdensome. Further, the board found that the granting of the respondent's variance would do substantial justice to the respondents and still observe the spirit of the setback requirement. And that was on page 12 of her decision. Then she elaborated and wrote, while the board identified and applied the McLean standard as outlined by the Court of Special Appeals, the board's conclusions did not provide sufficient findings of fact. So that was Judge Hong's issue. Yeah, you've identified it. Yes, you've discussed the McLean factors, but you didn't make a specific finding of fact for the basis for the practical difficulty. So she sent it back, and we had a very lengthy hearing where both experts testified, and you ruled based on the facts. And that was the second remand order. So that order was appealed again to circuit court. So we're back in circuit court for the third time in this case. All the while, this is all clouding the title of my client's house, and he can't sell the house. So Judge Addis gets the case. He offered to remand himself because he lives across, recuse himself because he happens to live across the street. But my client did not want any further delays. This has dragged on long enough. And so we proceeded in front of Judge Addis. And what he pointed out, which is very important again, was it was only the findings, this is regarding to the Court of Special Appeals, it was only the findings of the board as to zoning code 15-219-2. So subsection 2 of that long section that I'll recite to you in a moment, that the Appellate Court of Maryland was not able to affirm. In his reasoning, Judge Addis stated, first, the findings made by the board in their August 2nd, 2022 resolution were based on substantial evidence. And this is important as to where we are now. Clearly, Judge Addis has ruled that there's substantial evidence in the record. Clearly, there's no need for additional testimony, additional evidence. He found there's substantial evidence. So here we are at this juncture where he's asking us to reconcile, in my mind, the two previous orders. His issue, and we don't necessarily agree with this, but this was his issue, and here we are, is that the BMZA's previous discussions of the law were done without the benefit of the findings of fact. But you have the findings of fact when you heard it on Judge Hong's remand, and we had the experts testify, et cetera. So in our mind, all Judge Addis needed to do was look at the record with the expert testimony and the board's ruling, which made multiple findings of fact, and that would be able to reconcile both resolutions in this matter. But Judge Addis is now tasking you, the board, to reconcile the findings of fact that you made in 22 with the conclusions of law you made in 21. And again, we submit, and this is in a footnote in our memorandum, that if both resolutions are remanded or reviewed together, the issues presented as to law and fact can be resolved in our favor. Judge Addis apparently does not agree, so here we are. So the Court of Special Appeals is what started all of this. It's got up to the Court of Special Appeals, which, as I'm sure you know, does a very thorough job in reviewing the record on appeal. It's the second highest court in the state regarding appellate review. And it was very careful to point out that the required findings of 15-219 were met. There were no errors made by the board regards to 15-219. And I think it's important for me to recite 15-219 and the requirements for the record. Under zoning code 15-219, other required findings, the conditions on which the application is based are unique to the property for which the variance is sought and are not generally applicable to other properties within the same zoning classification. Here we've got a unique property. Uniqueness has already been ruled on. We've got this forest and conservation easement to the rear. The slope of the property requires you to put the landscape infiltration facility to the rear, which pushes the building envelope forward. Number two, and this is the one of the long list of requirements that the Court of Special Appeals wanted to hear more from the board. Number two is that the unnecessary hardship or practical difficulty is caused by the code and has not been created by the intentional action or inaction of any person who has a present interest in the property. Obviously, our argument to that case has already been made, but we'll make it again, and that is that it's the unique characteristics of the property, that is where this forest conservation easement is, where you have to do stormwater management, that push the building envelope forward. Number three, the purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property. This house is actually smaller than the vast majority of the houses along the street in this neighborhood. Number four, the variance will not be injurious to the use and enjoyment of other property in the immediate vicinity or substantially diminish and impair property values in the neighborhood. It's really important to point out the Court of Special Appeals found no errors with regard to how the board ruled on all these other factors. So these are no longer issues before you. Number five, the variance will not impair an adequate supply of light and air to the adjacent property. 2, overcrowd the land. 3, create undue concentration of population. 4, substantially increase the congestion of the streets. 5, create hazardous traffic conditions. 6, adversely affect transportation. 7, unduly burden water, sewer, school, parks, other facilities. 8, increase the danger of fire. Or 9, otherwise endanger the public safety. Again, Court of Special Appeals found the board ruled properly regarding those considerations. Number 6, the variance is not precluded and will not adversely affect any urban renewal plan or the city's master plan. Number 7, the variance will not otherwise be detrimental to or endanger the public health, safety, or welfare, or be in any way contrary to the public interest. Again, the board considered these factors. They ruled upon them. The Court of Special Appeals found no errors regarding their consideration of this. Number 8, the variance is in harmony with the purpose and intent of this article. And number 9, within the purpose and intent of this article, the variance granted is the minimum necessary to afford relief, to which end a lesser variance than that applied for may be permitted. Again, Court of Special Appeals found no errors regarding to all of these requirements, with the exception of identify the practical difficulty and explain how it's not self-created. And that's already been done, and the board's already ruled on it. But we're here again, I guess in the interest of thoroughness from Judge Addis's mind, to reconcile the other two resolutions that you've already issued. I'll quote from the Court of Special Appeals opinion itself, because it made a really important suggestion to the board way back when it first remanded this. It could be that without a 30-foot setback, the house could not have been built as designed because the landscape infiltration facility could not have been located anywhere other than the 10 to 12.5-foot gap. Although the board discussed the location of landscape infiltration facility at the hearing, the issue was absent from its order. So in essence, the Court of Special Appeals, again, didn't find any errors. They just wanted to see a reference to something that was already in the record. And I think that's what the board did on its first remand. But instead, Judge Addis has asked the board to discuss its findings of fact and the practical difficulty caused by the characteristics of the property that make it unique within the legal framework of the McLean factors. So for the record, I'll recite those 3 factors from McLean. That's the McLean v. Solely case. Number 1, whether compliance with the strict letter of the restrictions governing area setbacks, frontage, height, bulk, or density would unreasonably prevent the owner from using the property for a permitted purpose or would render conformity with such restrictions unnecessarily burdensome. Number 2, whether a grant of the variance applied for would do substantial justice to the applicant as well as to other property owners in the district, or whether a lesser relaxation than that applied for would give substantial relief to the owner of the property involved and be more consistent with justice to the other property owners. And number 3, whether relief can be granted in such fashion that it's in the spirit of the ordinance will be observed and public safety and welfare secured. And I've spoken to colleagues in the law department who co-counsel with me on this case when we've gone to appeal many times, and we recognize that these are factors that really require you to conduct a balancing test. You know, what's reasonable, what's not reasonable. We obviously are arguing before you that requiring to move this house back 10 feet really wouldn't do any additional justice to the surrounding neighborhood. It would still be well forward of Ms. Taylor's house and the other houses on the street. I fail to see where the 30-foot setback in lieu of the 40-foot setback is somehow causing interference with light and air and other things that zoning case law typically discusses. You've got aerial photographs throughout the record in this case. Could, number 1, show the scale of our house being actually smaller, but also show that there's a significant degree of separation. Ms. Taylor actually lives a couple doors down. Other than the fact that she doesn't like it when she drives by it, which she put in her letter to you all, I don't see where the general public health, safety, and welfare is diminished, as opposed to not allowing it and not allowing Mr. Naylor to build the house that he designed. And when I did speak to my colleagues in the law department, they pointed out something very interesting, and I think they're right. We really are, it's kind of winding the clock back in this and taking this all the way back to before anything was built on this property. My client got a permit to build this house. The city, thinking they were doing a favor to my client, revoked the permit so they could get it in front of the board so he could get the variance that they thought he should have gotten initially. But that's not where we are. Obviously, the house is built. The Court of Special Appeals reference, that's the gorilla in the room. It's already there. But even if you take it all the way back to before this house is built, you look at the property. You look at the unique characteristics of the property and what practical difficulty did that cause. And what it caused was the need to push the building envelope forward on the lot so that he could build the house as designed. And that's where we are. You're going to hear testimony and probably photographs of, this landscape infiltration facility, hasn't been built yet. Well, that's really not the point. The point is there a practical difficulty based on the unique characteristics of the property? And there is. And if you look at this before anything was built, of course nothing's gonna be built. This whole mess, I'll call it, for years, has clouded the title and prevented my client from doing anything. So the fact that he hasn't built anything yet as far as landscape infiltration facility is entirely moot at this point, and that was addressed by our expert at the hearing. So, at this juncture, we'll submit that the three factors in McLean, if you may consider them, if you do the balancing test, we meet those factors. The Court of Special Appeals has already ruled that we've met all the requirements under the zoning code for variances. There certainly is a practical difficulty. It was not caused by Mr. Naylor. It was caused by the characteristics, the unique characteristics of the property. You've already ruled on that. I think the board's already done its job before today. Judge Addis, I guess, wants you to do it one more time and reconcile the two resolutions that you've previously issued. And I'll submit it this time. Thank you.
So, Mr. Woolman, if we were to say to you, in light of the various remands and the state of the case as it is now, what is the identifiable practical difficulty established by your client in this case? Just, it's one blank, it's two blank. These are the things, because throughout these appellate opinions, they're saying, the board took all this information into consideration, but just say it factually as a factual finding. This, number one, this is a practical difficulty. Number two, this is a practical difficulty. Because then we discuss, and make a determination on whether any of those situations or that situation was caused intentionally by the applicant or not. Again, throughout this myriad of information that's been presented and we've heard and appellate courts have cited to, it may be in there. But if you could just state it very cleanly,
Sure.
we'd know what it is.
And I'll start by reciting the quote from the Court of Special Appeals again, because I think they almost did it for you. They kind of did. I mean, they said it could be, and we're now submitting it is, and you heard lengthy expert testimony regarding this, and I can cite to various things regarding the testimony, which I'll do for you now as well in response to your question, Mr. Chairman. But the court in Annapolis said that it could be that without a 30-foot setback, the house could not have been built as designed because the landscape infiltration facility could not have been located anywhere other than the 10 to 12-foot 0.5 gap. Although the board discussed this location, it was absent from its order. So again, the court is doing what they're required to do by the law. This is not about the design of the house. I want to be really careful to answer your question.
And why isn't it about the design of the house?
Because the law requires that you look at the unique characteristics of the property and what practical difficulty does that present to a landowner who's looking to build a house. Could he have designed a smaller house and fit it in there and be really small compared to the other houses in the neighborhood? Sure. Could anybody that's ever gotten a variance before this board or had a variance upheld by a court of law build something smaller to fit within the requirements of the code? Of course they could. But that's not what the law requires you to consider. What the law requires you to consider, and the Court of Special Appeals was careful to note this, is the property's unique characteristics. And what practical difficulty did that cause? I will turn to the testimony from our expert regarding the location of the practical difficulty, which is the landscape infiltration facility. We called civil engineer Patrick Richardson to testify before you in 2022. We introduced his resume as part of the record. He's testified before the board on numerous occasions. Mr. Richardson explained that he had done that he testified before you many times, had been accepted as an expert in the 3 neighboring jurisdictions. This was on page 29 of the transcript. This is all in the record. And to address the specific questions posed by the circuit court remand. And Judge Hong, I think the court did its job on Judge Hong's remand. Judge Addis obviously disagrees, but Judge Hong was very specific what to address. And Mr. Richardson testified regarding the stormwater management plan, which again is part of the record for the site, and he testified in detail regarding the property's topography, the practical difficulty in placing the required landscape infiltration facility elsewhere. There were suggestions that you could do paver stones, or like I mentioned, cisterns on the roof, and all these things just were not practical. And again, the board is required to conduct a balancing test under McLean and under the law to what's reasonable. And even Mr. What's his name? Even Mr. Olt said, I'm in favor of moving the house back if it's reasonable, but we submit it's not. So again, to address the specific questions posed by the circuit court, Patrick Richardson referenced the stormwater management plan and the subject property's topography, the practical difficulty in placing the landscape infiltration facility elsewhere, and that's on page 32, 36 of the transcript. His testimony included such statements as, quote, that's the only place it can go, and that's on transcript page 35. And in response to a question from you, Mr. Chairman, he responded to you, I don't see any other alternatives. And that was expert testimony from someone you accepted as an expert. Mr. McCann called Mr. Dan O'Leary to rebut our case in chief. He testified generally about various alternative stormwater management practices, but he conceded, and this is on page 59 of the transcript, that the practical difficulty associated with them upon examination again by you, Mr. Chairman, existed. There was a practical difficulty of doing it another way. So when pressed further, and I think it may have been Board Member Cunningham, the expert for, Mr. McCann's expert was unable to provide any exhibits or any evidence to support his contention. He testified a lot about general stormwater management procedures, which I'm sure he's very knowledgeable in, but he was not able to rebut what our expert testified to regarding where this facility needed to go. And that, to answer your question, hopefully, Mr. Chairman, that is the practical difficulty. All the factors I listed under the code, you've already ruled upon, and the court didn't have any issue with it whatsoever. So you're not here to reconsider that long list of requirements. You've already done that. What you're here to do, again, is to identify the practical difficulty and reconcile it with the findings of fact that you made based on the expert testimony, and rectify it with your analysis of the McLean factors. And let's not forget, all those other factors I recited from the zoning code, the fact that you ruled that none of those things were violated, that kind of tilts the balancing act in our favor, I would submit. I mean, there's a long list of factors that I listed, and you already ruled upon that, and the court in Annapolis didn't have any issue and literally, quote unquote, found no errors in that regard. So I would submit that, as the court suggested, the location of this landscape infiltration facility that had to go where it had to go, push the envelope, the building envelope forward. Again, in discussing my conversation with members of the law department, if you look at this from the standpoint of back when he applied for the building permit, he should have gotten the variance then. The city issued the permit to him due to no fault of his. He got a permit, he built the house. If you look back as if this case is in the posture where nothing yet has been built, it's not about the design of the house. It's about what difficulty does this characteristic on the property present the landowner from building a house? And what it does is it pushes the building envelope forward, and that's the envelope from within which he has to build his house. Someone could certainly stand up and say, well, get rid of the third garage door on the garage, and then you'd meet the requirements. That's not what the law requires. The law requires you look at the practical difficulty caused by the property and what that practical difficulty was as far as pushing the envelope forward and allowing him to build the house. If the answer is always build something smaller, we'd never have variances, ever. So I'll submit this time.
Thank you. Any questions for Mr. Woolman for now? No. All right. Sir.
Thank you, Mr. Chairman. Good afternoon, everybody. I'm going to start where Mr. Woolman started, and I think I'm glad he started where he did. He referenced an email that was in the record where someone suggested that you can't move the building. You should only be able to move the building back unless it was reasonable to do so. And I think that's the fundamental problem we have here, and that is that according apparently to Mr. Woolman, the standard is today, is it a practical difficulty or unreasonable hardship to move this building as it stands today back 10 feet? Of course that's a practical difficulty. That would be very difficult. It'd be expensive. I think we had some evidence below that it would cost tens of thousands, $90,000 or something to move the house. That's not the standard. Of course it would be a practical difficulty. The standard, members of the board, and I know this is it's even hard in my mind to distinguish the two, is whether back then, before this building was ever constructed, would it have imposed a practical difficulty to build the building that he wanted to? That's the issue. We got to ignore the fact that the house is there now and look what happened back then. I mean, there are a lot of cases, and I'm sure you guys may be familiar with some of them, where people have sought variances after the fact. They did something in violation, even there's setback cases. There's lots of setback cases. They construct something in violation of the setback, then they go to a board like yourselves and they ask for a variance after the fact. And the appellate courts have said over and over and over again that the fact that you built something in non-compliance with the zoning ordinance is not the practical difficulty. So let's go back in time. I'm glad Mr. Woolman said that because we can put all that aside. That's not the issue before the board today. And look at what happened back before 2017 when this was first applied for. And I think, secondly, before I guess to my prepared statements, is Mr. Woolman did not address at all the issue that's in front of you guys in this remand, and that is, did Mr. Naylor intentionally, through inaction or action, create this practical difficulty? Create it. Was it self-created? That's the language of the law, and I'm sure the board is very familiar with it. And there's lots of cases that talk about what it means to self-create a practical difficulty, lots of them. The appellate courts have said, and this is the Court of Appeals in 2014, said the critical inquiry in determining self-creation is whether the applicant could have avoided the need for a variance or had a hand in creating the circumstances that causes need for a variance. That's the standard, and I've been doing this 20 years. I can't think of a more perfect case than this one where the practical difficulty was self-created. It was Mr. Naylor's own doing. And just to refresh, all of this is in the record, by the way, refresh your recollection. Mr. Naylor purchased this property back in 2014. When he purchased the property, his deed made reference to the final subdivision plat for this small subdivision that this property is part of. When you go to that subdivision plat, it has an 82-foot setback on that final subdivision plat. Mr. Naylor knew or should have known that there was an 82, not a 40 or 30-foot setback, but an 82-foot setback in the final subdivision plat. In fact, also part of the record already is Mr. Naylor's title insurance policy. He received the policy when he purchased the home. And part of, if you're familiar with insurance policies of that type, there are exceptions to coverage. And one of the exceptions is the restrictions, conditions, setbacks as set forth in the final subdivision plat. So again, Mr. Naylor, referencing a deed to a plat, the plat itself shows an 82-foot setback. He gets a title insurance policy that says, we're not going to cover you if you violate that 82-foot setback in that final subdivision plat. So again, my point in all of that is Mr. Naylor knew or should have known about an 82-foot setback, much less the 40-foot setback that's in the zoning regulations. And this board is very familiar with the proposition of law that ignorance of the law is not an excuse. Mr. Naylor, to be more honest and to be frank about it, Mr. Naylor's consultants, the professionals he hired, regrettably, to prepare a site plan and to put this building where it is, they didn't know that the setback was 40 feet. They submitted to Mr. Naylor a plan that showed a 30-foot setback. So their ignorance, Mr. Naylor's ignorance of that 40-foot setback is not an excuse. In fact, it's the exact opposite. It's a suggestion of intention, action or inaction that created the practical difficulty. So I don't think there's any question that Mr. Naylor and or his consultants knew or should have known about the setback requirements. And I want to stop there because I do have a prepared packet. I don't want to just be referencing exhibits that you may not have seen for quite a while. So I have prepared, for the board's reference, 10 documents. I have a copy for Mr. Woolman, of course. 1 second. Here you go. Thank you, John. May I hand these to you guys?
Absolutely.
Okay. Thank you. And I've referred to a couple of these already. I don't want to distract you with all these documents, but the first.
Sorry, do you have one more for me?
Oh, I do. I'm sorry, Becky. Yeah.
I've already referred to the first, second, and third documents in this tab, in this exhibit binding that first one, of course, is the deed. The second document is the final subdivision plat that's recorded in the land records. I highlighted, though it's a bit difficult to see, the 82-foot setback in this subdivision plat. And the third tab, of course, is the insurance policy. And again, I've highlighted the exclusion from coverage for setback restrictions, lines, it says actually. The other thing I wanted to point out, at tab 4 are the actual house plans, the details, the bedrooms, the bathrooms, the garage, all the details of this particular house. And Mr. Woolman said that the design of this house is irrelevant, that the board should just accept what Mr. Naylor wanted, and we should just accept that. He wanted a house, he wanted a breezeway, and he wanted a 3-car garage. That's not at all what the courts have said when they've looked at this issue. In fact, the circuit court said explicitly, upon remand, and this is in the circuit court's ruling, January 5th, 2022, it said that the board's resolution lacks substantive findings to support the conclusion that Mr. Naylor's house could not have been designed in any other way. And the circuit court remanded with a specific instruction that it was essential for the board to obtain substantive evidence from experts or witnesses other than attorneys who could make it clear that Mr. Naylor had no other option to design and build his home other than the way he did. That's at pages 13 and 14 respectively of that decision. And my point, my second point, aside from the history that I just described, my second point about what is intentional about what Mr. Naylor has undertaken is that he has never, in this case, never, we've been in front of you guys a lot, he has not once appeared before you or has his attorney submitted any evidence that the house could be built in some other way, that we could have a 2-car garage. Same exact house, breezeway, 2-car garage. Same exact house, no breezeway, 3-car garage. There's been no evidence, really there hasn't even been the contention by Mr. Naylor's attorney that they couldn't have done it that way. You know, I can think of examples, and I'm sure the board could, where maybe it is necessary to have a 3-car garage because, you know, a family member, his family has a handicap, and they need an extra large space for the van that needs to accommodate that person. There's been none of that in this case. And those were part of the instructions in the circuit court remand was, tell us whether or not it can be designed any other way or not. And we haven't heard a whiff of that throughout all the days we've been in front of the board. So that, to me, again, is evidence of intention, action or inaction. I think it's a fair inference that from the lack of evidence, members of the board, that he could make it smaller, even a little bit smaller. We're only talking about 10 feet. Remove the breezeway. Do you really need a covered breezeway? Just remove that and have a 3-car garage in the very same exact house. And that's, I think, a second critical lack of evidence in support of intention, action, or inaction. There just simply hasn't been any of that evidence. And at tab, I submitted to you guys the house plans because I wanted to show you the extent of the house. And this isn't a 1-bedroom house with a half bath and a 1-car garage. This is an extensive house. In the absence of any evidence to the contrary, clearly could have been reduced just a little bit to accommodate the setback. And then I also included at tabs 5 and tab 6 the stormwater management plans, which maybe the board recalls those, and actually the site plan. And I've highlighted in yellow both of those plans just to make the simple point. At tab 5 in particular, the stormwater management, you'll see the so-called landscape infiltration facility that we're talking about. I've highlighted a portion of it on the stormwater management plans. You see it there. It's in the plan. And then you go to tab 6, and I highlighted in yellow the area behind the house. This is the site plan at tab 6. This is the area behind the house, rather behind the garage, and the beginning of the forest conservation easement. That area, if you do the measurements and do the math, it's well beyond 10 feet. So the whole house could be moved back without touching the forest conservation easement. The other thing there was no proof of, and I think this is what the remand called for, is you'll notice in the stormwater management facility, that a portion of the driveway was, I guess, changed to accommodate the facility. It was sort of rounded off. There's no, let's assume, is everybody with me? I know it's very difficult to see, very difficult to see. Let's assume that the very same landscape infiltration facility is absolutely required. You could not make this house an inch smaller. You could still move the house back, the breezeway back, and the garage back. You'll see there's room there just north of the infiltration facility. Leave the infiltration facility there and just have a little bit smaller access to the garage. Just a little bit smaller to accommodate the landscape infiltration facility. So there was no testimony on that front, and I believe there should have been, for instance, that the garage couldn't be, or the entrance to the garage couldn't be accommodated to accommodate the landscape infiltration facility. Lastly, beyond all of that, so putting aside, members of the board, the fact that Mr. Naylor knew or should have known about the setback, putting aside the fact that there was no evidence to support that he could not have built just a little bit smaller house, that's number two. Beyond all of that, we know as we sit here today, after all the time we've spent in front of the board, all the time my client has spent in front of the board, all the time Mr. Leary has spent in front of the board, the landscape infiltration facility was never installed. It's not there. I asked this of their expert during the last hearing, and he agreed it's not there. I showed him an aerial photograph, which, by the way, is at tab 7. You'll see, this is an aerial photograph from 2022. And if you turn it this way, you'll see the pad, you'll see a basketball hoop there, and the landscape infiltration facility isn't there. And Mr. Woolman's expert agreed it wasn't there. At tab 8, I have some more recent photographs from the adjoining property that show up close, as opposed to an aerial, that there's nothing there. There's no facility there. So it was never actually installed. So what do we make of that? You know, they're in violation today. They submitted a stormwater management plan and they didn't install the facility. What does the board do with that? Is it another violation of the law? Do we just ignore it? And I think this is, I was having difficulty articulating this to my client, but I think this is the significance of there's no facility there. It's not so much that they're violating the law today. They are. They didn't install it. Somehow they got a building permit, and they didn't have, the inspection didn't notice that the facility wasn't installed. But the point is this, if it is not necessary to install it today, let's go back in time, back before this thing was ever constructed. Did they have to construct it back then? The answer is no. That's what this absence, yes, it's a violation of the law today as we sit here today, but the real point in all this is it shows, I think it's proof positive, frankly, members of the board, that such a facility was and is not necessary. It's not the only alternative to stormwater management. And frankly, that the practical difficulty that we've been talking about for 5 years never existed in the first place. It was a fabrication, for lack of a better word. There's no such difficulty. And we, following the hearing and even following Mr. Woolman's expert's concession that there hadn't been installed, we went to the city and we asked, has it been installed? And we have at tab 9, members of the board, we have an email exchange with Kim Grove. You may be familiar with Ms. Grove. She's the Chief Office of Research Environmental Protection for DPW. And we asked her about what happened, essentially. Was it installed as Mr. Woolman's expert said? And and I've highlighted the relevant portions of her responses, but effectively what she says is no construction, no as-built drawings were ever submitted. Usually when you prepare a plan and you install a facility, you submit the as-built to the city. You get an inspection and they sign off on what was installed. None of that was done. And she acknowledged, based on the aerial photograph, that the facility was, in fact, not installed. The other thing I think that's very, very important about the email exchange and I have Mr. O'Leary today, if the board would like to hear any evidence on this, is Ms. Grove, when asked in these emails, was, is there another alternative to this facility? And she says, yes, there could be a fee in lieu. In other words, in lieu of installing today the landscape infiltration facility, Mr. Naylor could pay a fee in lieu, and that happens, I think the board can take judicial notice of the fact that that happens a lot with stormwater management facilities. You pay a fee and you avoid having it. So I think that's also very telling and also supports that as we sit here today, this so-called practical difficulty in the form of this landscape infiltration facility is a fiction. So just to recap, and I want to make sure I do recap because I know I've said a lot. The issue for the board, again, which Mr. Worley, I didn't see any mention of this in his memorandum at all, but the issue is, did Mr. Naylor do something through action or inaction that suggests that the practical difficulty was self-created? Let's assume what Mr. Worley said is the practical difficulty, that it is this landscape infiltration facility. Let's assume that. The question is, what did Mr. Naylor do? And I think through the three pieces of evidence I just summarized for you, number one, there's a long history of him knowing about this setback, or should have known about the setback, through the deed, through the subdivision plat, through his insurance policy. Number two, throughout this case, he never once introduced any evidence or even contended, he doesn't show up at these hearings, contended, members of the board, I can't build the house I want. It's necessary to have a house of this size. I can't build it 10 feet smaller. I can't not have a breezeway. I have to have a breezeway. There's none of that in this case. That second piece of evidence I would submit to you is also evidence, good evidence, if not proof positive, that this was done through the hardship of his own doing. And then lastly, the simple fact that the facility has never been installed. 5 years later, we're sitting here, and the practical difficulty that was suggested, frankly, after the fact, is a fiction. The McLean factors, I can go through those, but I think given what I've just said, those factors apply. Even if you were to apply the McLean factors, maybe even just the first one, you don't need to get past the first one. The question is whether or not compliance with the setback would unreasonably prevent Mr. Naylor from using the property for a permitted purpose. And I don't think there's any question that, given the history I just described to you, that that is not what would happen if the setback were enforced. And listen, I think I said something like this last time. I think this whole affair is unfortunate. I think it's unfortunate that the courts have had to spend so much time, that the board has had to spend so much time. Arguably, it's unfortunate for Mr. Naylor himself because, you know, I think it's clear, I think it's a fair inference, that his professionals screwed up. His professionals submitted a plan that violated the setback. His professionals built a house that violated the setback. So he may have a case against them. But the issue for the board today is one of the law. And frankly, I don't think the board should be considered, should be taken into consideration, you know, whether or not the building has to be moved back or not. The law is the law, and the law should be followed, period. It's unfortunate, but I would suggest to you, and this isn't no leap of faith here, I think Mr. Naylor has another remedy. It's not before this board, but he has another remedy, and I think we ought to keep that in mind just as a practical matter. So in my mind, members of the board, this is a classic example of a self-imposed practical difficulty that the law does not recognize. So I'll leave it with that. The only other thing I would suggest to the board, I do have Mr. O'Leary here. I could briefly tell you what he would say, or I can ask him the questions. It would just be 2 or 3 questions. But I can summarize what he would say first if you'd like.
Why don't you do that?
Okay. So Mr. O'Leary, if you recall, he is a civil engineer, specializes in stormwater management. He is actually employed by the city to review the very type of plans that we're talking about. He does that as a consultant. I know the city shops a lot of that stuff out. And he's one of those folks that does this. Mr. O'Leary would tell you, based on the aerial, number one, based on the aerial photographs and the photographs that were more recently taken, the landscape infiltration facility was not installed. He'll tell you that. You can plainly see that. Number two, as a matter of course, Mr. O'Leary will tell you that fees in lieu, that is the payment of a fee in lieu of actually installing a landscape infiltration facility or some other stormwater management measure, are done routinely, and that it is entirely feasible for, or not today, but it was entirely feasible for Mr. Naylor back before this house was constructed to pay a fee in lieu of having to install this facility that allegedly has created the practical difficulty. And his,
I have a question about that.
sure, sure.
The purpose of the landscape infiltration system is, I guess, for the protection of various, of the property and other things. I mean, why put it in? Based on the record that we have received, there was testimony as to why it's needed. And so it's just news to me that you can avoid putting something in that otherwise would be there and useful
Yeah.
by paying a fee.
Yeah, well, that's a good question. I want to be careful about what it is that Mr. Richardson said. Mr. Richardson did not, Mr. Richardson, and I disagree with Mr. Woolley's characterization, Woolman's characterization. He did not say that this facility was necessary on this property or else stormwater management could not be handled. What he said was, if we assume that this is the facility that we want, this is where it has to go. There's no other room for it. So that's a big difference. I know it's a very subtle distinction, but he was saying, and he was presented, he wasn't the designer, so he was presented with the theoretical. The question posed to him was, is this facility, can it be put anywhere else other than in this location? I think I could come to that conclusion, frankly, because you look at the site, you have the forest conservation in the back, you have the front yard, which has other stormwater management measures in it. You don't want a landscape infiltration facility in the front yard. So I think that was an obvious question that he obviously answered. But that's not the question I think you were getting to, Mr. Fields, and that is it necessary? Yes, it's necessary to have stormwater management, but this is a small property. The purpose of these measures is to prevent runoff onto other properties, and the city has made and every day makes decisions, business decisions about whether or not to allow a little less surface to be treated. You know, have to treat. It's really engineers do the math and they figure out we have this size site, how big of a facility or how little facility do we need to handle this much runoff? It's a numbers thing. And the city has made the business decision, as a matter of course, to allow folks to pay fee in lieu, because we're only talking a very small property with a very small amount of runoff. Remember, the property's flat. So, but Mr. O'Leary would say, as I've said, that it is entirely feasible, and he does it regularly, to get a fee in lieu for this type of facility. I'm not sure I answered your question. I hope I did. Yeah.
It did.
Mr. Chairman, I'm going to have to make a statement for the record here, because this obviously is going to get appealed. It always does. So I want to be clear on the record. I think permitting additional testimony from the same expert that the board spent hours examining previously is in violation of Judge Addis's remand order, where he specifically found that the board's decision was based on substantial evidence, and even suggested that the board need not take additional testimony in this matter, to allow the same expert, to allow them to get a do-over at this point, I don't think is in keeping with Judge Addis's order. If, Mr. Chairman, if the board disagrees with my objection and allows this expert to be called, and I had a conversation with your executive director about how we were proceeding today, Mr. Naylor has spent enough time and money on this. My understanding was this was going to proceed on the record pursuant to Judge Addis's order, which is that your prior rulings were based on substantial evidence. If we're going to reopen this up again, then my client needs to be given the opportunity to have his expert come back as well, which his head's gonna explode when I tell him this. But if we're gonna go this route, then I would ask that the matter be postponed and we'd be allowed to bring our expert again. But I think it's completely superfluous at this juncture and in violation of Judge Addis's decision. You've already heard from the experts. You've already made your ruling, and the circuit court found that your ruling was based on substantial evidence. If we're gonna open all this up again, then we need to be given that opportunity. And it was my understanding, based on conversations with your executive director, that our expert was not needed today, that we do not need to have additional testimony. And more importantly, Judge Addis ruled that you don't need to have additional testimony.
Well, didn't Judge Addis say that this doesn't necessarily mean that new testimony needs to be taken?
But more importantly, he states, and let me find where I quoted it.
While he's doing that, may I just respond real quick? I want to make clear about what Mr. Leary, what I'm proposing in terms of the proffer. I'm not suggesting that you're to rehash the evidence that we were.
That's been received.
Yeah, that's been received. Not at all. To the contrary, we're focused on the issue of intention, inaction, or action. And this all goes to the fact, let me try to say this explicitly and clearly as I can. The fact that this facility is not there, the fact that it could, back then, have been handled with a fee in lieu goes, I think, directly, Mr. Chairman, to the issue of whether or not this was intentional, whether there is a practical difficulty caused by action or inaction of this property owner. I think that's the limited purpose for which it's offered, and I don't think I'm not at all asking the board to rehash anything that's already found.
And obviously, Mr. Chairman, I've got responses with regards to Mr. McCann's arguments regarding what practical difficulty is. I understand why he's doing what he's doing. He's in a position where he needs to try to put as much out there for you to consider to cloud the issue. But the Court of Special Appeals nowhere in its remand, and that's the important remand in this case, mentioned the design of this house. It's about the conditions of the property itself. And Mr. McCann has known that all along. This is the exhibit that he produced before you on multiple occasions with his green arrows drawn and the house as designed. And his arguments have always been, you could move this same house back 10 feet. You've already heard from the experts that it would go into where the landscape infiltration facility would go, and you can't move it back 10 feet. This is not about ignorance of the law, and I'll quote from Stansbury v. Jones, 37 Maryland, 172. It should not be within the discretion of a Board of Appeals to deny variance solely because a purchaser bought with knowledge of zoning restrictions. So while it sounds nice to say ignorance of the law is no excuse, there are cases from the Court of Appeals in Maryland that rule that it's not a self-created hardship to purchase a property that has restrictions on it. If we're going to go back and get into the design of the house and experts testifying about landscape infiltration facilities, we are in violation of Judge Addis's order. He ruled that your decision was based on substantial evidence. That's what he ruled. There's no need to take more evidence at this juncture. The record is sufficient. Mr. McCann, as he's done all along, and I don't blame him, he's doing his job, but he's improperly trying to expand the scope of what you're reviewing. What the appellate court said was identify the practical difficulty. They even told you what it was. It's the location of the landscape infiltration facility. We've already taken testimony about the landscape infiltration facility and why it needed to go where it went. Whether or not you can pay a fee in lieu of does not matter. You're looking at the conditions on this lot and what practical difficulty resulted. And the practical difficulty, as I've said, was it moved the building envelope forward. You know, you can't look at the design of the house, say build a smaller house. Look at the building envelope and what the location of this facility did. It moved it forward. We've already got substantial evidence in the record. I would object to receiving additional evidence at this point. If you are going to receive it, and then allow us a postponement to have our expert come in and rebut what is said. But I think this is superfluous at this point.
Are we not also required to answer the second question of whether or not any intentional action resulted in the practical difficulty?
You are, and again, the Court of Special Appeals and Judge Addis both carefully pointed out that the practical difficulty was, and Judge Hong even wrote it in her opinion. You've already ruled on this. We're back ruling on it again. And Mr. McCann stated that I didn't bring it up in my memorandum. Brought it up a couple different times. I guess he didn't read my memorandum. But in referring to the remand, the first one from the Court of Special Appeals, explain how the parameters of 15219 are fulfilled. This applicant viewed this to be relatively straightforward. Asked the forest conservation easement that forced the applicant to place the required landscape infiltration facility in a particular area predated the applicant's interest in the subject property and were, quote, not created by the intentional action or inaction of any person who has a present interest in the property. Judge Hong went even further, and this is also in my memorandum, and recited your findings, which you've already made. It's law of the case, basically. It's classic law of the case, even though this isn't a court of law. The board finds that unique characteristics of the property, which predated the nailer's purchase, created the practical difficulty in designing a home that met the needs of the applicant, was in harmony with other homes in the neighborhood, and adhered to the strip application of setback requirements. You've already ruled on this. You've already taken expert testimony. We should be done now. And with, again, regard to self-created hardship, I cited the Stansbury case, which cites another case, Rosser. It should be noted that it should not be within the discretion of the Board of Appeals to deny variance solely because a purchaser bought with knowledge of zoning restrictions. Mr. McCann would have you believe that because Mr. Naylor's deed referenced the subdivision and there were covenants, and all those things, by the way, have already been litigated at the circuit court in an entirely separate action that my client prevailed in. This has been going on for years, but he's basically trying to expand what you're reviewing at this point, and I don't think that's proper.
Hold on, I'm looking at the last page of Judge Addis's decision, and states fairly clearly, on remand, the board must articulate why or why not the practical difficulty in this case was self-created. Specifically, if the board finds that there is a practical difficulty, which suggests that we still should be considering that factual determination, I know what the history that you pointed out in the record is as if the board finds there is a practical difficulty, the board must also find whether or not that practical difficulty is caused by this article and has not been created by the intentional action or inaction of any person who has a present interest in the property. Just as in the previous section, in order to answer this question in the context of findings of fact, this court leaves it to the board to decide if more evidence is needed to supplement the testimony from prior evidentiary hearings before they can issue a new resolution. So didn't Judge Addis expressly leave open whether or not you take in new testimony to answer both of those questions?
Judge Addis left it to the board to determine whether substantial evidence is required and new testimony is required. I'm submitting to you that the record is already substantial and that he also ordered in his order that your decision was based on substantial evidence. And with regard to practical difficulty, the Court of Special Appeals identified what that could be. We then took expert testimony as to what that is. And this is so important. It's not the design of the house. It's the forest conservation easement and the stormwater management regulations that require you to put a landscape infiltration facility in. That's already been testified to. Clearly, and I cited the case from Stansbury, I cited Judge Hong's order, the forest conservation easement and the stormwater management regulations predated Mr. Naylor's purchase of the property. Certainly, the board can understand that that's not self-created. Mr. Naylor didn't draw the line where the forest conservation easement goes on his lot. Mr. Naylor didn't enact the stormwater management regulations. All these things predated the purchase of the property, which is why Judge Hong was so careful to point that out. If we're just going to keep expanding the scope of this and further delays this again, I'm going to have to ask that we further delay it so that we're allowed to respond. But I don't think it's proper to take the additional testimony at this point.
I think I disagree with that, Mr. Wallman,
Okay.
because I think that the remand for which we're here expressly stated that you could take more evidence.
Then
Clearly, that would be available to.
I would respectfully request, given what I was instructed by your staff and the fact that we were told we did not need to bring our expert here today, if we're going to allow us to go down this path, that this matter be continued so that we may call an expert to respond.
Well, just so the board is clear and the record's clear, what were the parameters that you were advised that we would be here for?
I'm sorry?
What were the parameters under which you?
I specifically, I went to the board's office last week to review the file to see if anything had been filed by Mr. McCann after I sent him a copy of my memorandum. Nothing was filed. He brought it all today, so we didn't have any advance notice of that, number one, but that's okay. That's his prerogative. But I specifically had conversations with your executive director as to how we're going to proceed, and specifically said and mentioned that my client has spent a great deal of time and money in this matter based on our reading of Judge Addis's order, which I understand, Mr. Chairman, you disagree with, that we should not be required to pay and bring an expert in again to testify, and that no more evidence was going to be taken. I was told I would argue first, Mr. McCann would be able to argue second, and then I would have the final word in the argument. So I was told arguments were going to be made today, not that we'd be going through a full hearing with expert witnesses being called to testify. And I'm not trying to throw Ms. Witt under the bus.
I want to be fair to you with, well, clearly what we're trying to avoid is yet another remand.
I understand.
And the court saying, well, we sent it back, you're supposed to figure this out and find this out and state specifically on the record what you found. You didn't do it. Do it again. Didn't do it. I think we've got an obligation here and a duty to make those findings that the court's asking us to make. And it is asking us to make two, notwithstanding what the record says. Certainly we could, the board in its discretion could, I guess, look at what's been identified in the record and say, oh, here it is. We just didn't state it. But there are more, if there's more information that's relevant to and goes to the factual issues that we got to determine, that's the job I guess we've been tasked with. And so, particularly on the issue, on the latter issue of self-creation, which the appellate court and I guess the circuit court was clear about. We need to be able to make that finding. I hear your argument as to why we necessarily have to conclude that it's not been self-created, because these things predated the purchase of the home. They existed, the stormwater management facility or the requirement and the forest conservation.
Mr. Fields? Mr. Fields, may I say something real quick? I didn't want to break up your train of thought, but I think
Go
I
ahead.
did. But two things, and you just referenced it. The case that Mr. Woolman's referring to, which stands for the proposition that the purchase of a house cannot be the practical. That's not our argument. It's not the purchase. It's the construction of a building on this property that is being claimed to be the practical difficulty. And on that point, the courts have clearly said you can't construct a building, try to seek a variance, and then after the fact say that was the practical difficulty because I constructed a building that violates the law. So I want to be clear, it's not the purchase of a house that we're saying can't be the practical difficulty, it's the construction of the house. Number two, at least I want to be heard on this issue of reopening the evidence so Mr. Woolman gets a chance to bring some testimony in. I think you read from, I think anybody, I think my 13-year-old reading this opinion, Your Honor, Mr. Fields, would draw the conclusion that there may be some evidence at this hearing, and if, so he was on full notice, and I think it's unfair on our side of things after all this time to prepare for a hearing, come to the hearing, and Mr. Woolman should have known that that was a possibility, having read the decision and anticipated that, to now allow him to come back really on what is a very narrow issue, Mr. Fields, and that is this, the only new evidence. Remember, the evidence about this facility not being installed was brought up at the last hearing. I asked his expert about that. I showed him the aerial photograph, and he agreed at page 43 of the transcript that it wasn't installed. So that's already in the in evidence. The only thing new is this affidavit, is this email from Ms. Grove saying, you're right, it wasn't installed. We didn't do a construction inspection because as-built were never submitted. We didn't inspect the property, and a fee in lieu is a possibility to get around all of that. That's the only thing that's new that I'm presenting today. It shouldn't, so I want to be clear about that. But in the first instance, I think Mr. Woolman should have been fully aware that this possibility of some evidence, and the board doesn't have to accept that evidence. It was a proffer. But I think it would be unfair at this point just to reopen the hearing.
Mr. McCann just contradicted his entire argument when he said the construction of the house is the practical difficulty.
I said it was not.
It was not, is the practical
Cannot be
difficulty. He started out by saying, I was right, you take this back to before anything was built. The design of the house is not the issue. It's the characteristics of the property that's the issue, and you've already made that proper determination. It's not the design of the house and could he build a smaller house. That's not the issue. The issue is, and the Court of Special Appeals identified it, was there a practical difficulty due to the unique characteristics of the property? This is not about Mr. Naylor can build a smaller house.
Then why did the circuit court remand on that basis?
Hold on. And this is just a question that goes to the that issue, that a house cannot create. It's not the design of the house. The fact that these conditions existed on the property, the requirement of a storm, a landscape infiltration system, the forest conservation. They exist. The argument is you have to abide by those, so we have to deal with that,
Or get a variance.
or get a variance.
And a permit was issued in this case.
As a factual matter, could it be argued that neither a variance could it be contended that the ability to pay a fee in lieu of creating and installing a landscape infiltration system is an alternative? As an alternative, which would allow you to abide by the setback, by the required setbacks.
I think, and I could almost, I think I could almost admit and almost accept a proffer that perhaps that's an alternative. But again, let's go back to, and Mr. McCann said he was glad I pointed this out. Let's go back to as if this case is coming before the BMZA in 2017, and Mr. Naylor has a reduced building envelope because of
things that exist.
Because of these things. And this is the house he wants to build. He's got rights, he's a property owner, he's building a house, it's not some monstrosity, it's a lot smaller than the other houses in the neighborhood. And he is now requesting you, the board, to grant him a variance to build the house that he wants to build. The board needs to take into all the considerations of 15-219 that I already listed. And you all did that after the fact, but you did that. We need to look at this as if this house was not built. Did the board make a proper determination regarding the variance standards to grant Mr. Naylor a variance, albeit retroactively? The Court of Special Appeals found no errors in your review of the original variance application for this house, as if the house was never built. What Mr. McCann is asking you to do is expand that scope and rehear an entire variance case. And that's not what we have before you. What we have before you is all of those factors, with the exception of the one, and that's self-creation, were properly ruled upon by the board. So now the board determines whether or not the practical difficulty was self-created. I think it's quite obvious that Mr. Naylor did not create the forest conservation easement nor the stormwater management regulations. So again, we go back and look as if nothing's been designed and built yet. He's asking for you to grant him a variance. So then you look at the McLean factors, which the court did specifically ask you to look at. And you look at the balancing test that I talked about. We're talking about allowing him to have a 30-foot setback in lieu of a 40-foot setback. That's what this is all about. This many years of litigation is about 10 feet of setback. Even if we lost everything, I mean, we've been prevailing at every stage, but say we've lost at every stage, and we've been appealing, and we've been losing, the remedy is to move this house 10 feet back. How does that address the spirit of the zoning regulations and the setback requirements? If you're looking at this before this house was designed and built, is it reasonable for the board to give Mr. Naylor 10 feet of setback relief to build the house that he wanted to build on his property? Why does he need that relief? When I talked to Mr. Naylor about this case, he's like, I would have loved to have built this house 100 feet back from the street. I would have loved to have done that, but they wouldn't let me. You know, he's like, the environmentalists wouldn't allow me. The forest he's not happy that there's a forest conservation easement at the back of his property, but it's there, and that's the practical difficulty. So if you take this back and look at it from the initial phase before anything's built, the board's job is to look at all of those factors, all of them, and you've ruled already on all of them, and determine whether or not it's reasonable to grant this variance. And you've done that. And I submit that it is reasonable to grant the variance, and you've done that. The court's asked to identify the practical difficulty caused by the property, and that's really important. The Court of Special Appeals, the original remand, asked you to identify the practical difficulty and then even suggested the answer to the question. And so we've done that. We've taken expert testimony regarding that, and I would submit that really you can take both your resolutions. Your first resolution addressed the McLean factors and the law. Your second resolution addressed the findings of fact. Judge Addis was clear. He said that your first resolution didn't have the benefit of findings of fact. Well, now you do have findings of fact. They're already on the record. And those two resolutions can easily be rectified and a new resolution can be submitted.
Okay. Anyone have any questions for parties?
Yeah, I do. Why didn't Mr. Naylor build the filtration system?
And Mr. Richardson and Mr. McCain keeps referring to the fact that Mr. Richardson admitted it hadn't been built. But if you look at the record, which again, I asked the board to do in this case, in the record, he explained that it made sense that he not build it yet. This is all still in litigation. He doesn't know where this is gonna end up. And he, to your satisfaction, if I recall, explained the answer to that exact question at the last hearing, which is why we don't need to have another hearing on it.
With all due respect, he absolutely did not, Mr. Cunningham, did not say those words, did not infer anything to the like, that it wasn't installed because litigation was ongoing. It
Well,
just
he
wasn't
said
installed.
it made sense that he
Yeah,
hadn't installed
well,
it yet. I'm not
find
gonna.
that, I'm sorry to, it's an important point. You can't just say things. I'm sorry to interrupt.
And the record
Yes.
is, we all say.
I
will
asked you to
speak for
refer to the
itself.
record, right, refer to the
And so we defer to the record.
Thank you.
Which we ultimately will. And part of deferring to the record is having some help in doing that. In other cases, we've had, this is a remand, after many remands, asking us to make findings of fact. You know, after a lot of these cases, we ask for a briefing on findings of fact and conclusions of law, you know, citing to the record and supporting your claim or the other with evidence. So I would think we would want that from you. A briefing, and we can set up a briefing schedule for that.
Sure.
Great.
But that would be helpful, given the length of time in this matter and the volume of the record. It would be helpful to focus us in on those particular portions of the record that allow us to answer the questions that multiple folks seem to say we should keep doing. So we'll do that. Do you want to? We need to do that now?
To schedule when that would be due. So it'd be a proposed memorandum with
Right.
findings of fact and conclusions for the board to review, and then you would deliberate after you receive
Correct.
that. Yeah, I mean, it doesn't matter to me when they're due, so what would be a reasonable amount of time for that, do you think?
I'll frankly ask the parties if
The sooner the better, while it's
Okay.
fresh in everybody's mind.
okay.
2 weeks, 3 weeks?
2 weeks sounds good.
Would
Mr.
that,
Woodland?
Sure.
okay, so that would
Just take a look at my
be,
calendar, I'm sorry.
Yeah.
Might want to do that.
I
So
mean,
that would be back before the briefing would be due in 2 weeks, would be the October 3rd, correct?
yeah, the board would need some time to review it, so I don't think they could deliberate until the following set of hearings, which would be the 17th. So if you want 3 weeks, I think that would be fine. So that would be October 10th it would be due, and then the board would deliberate on the 17th.
Great.
Would that be okay with
Yes.
everyone?
That work?
Sounds good.
Great.
Sounds good.
Thank you very much.
Thank you. Thank you for your time,
you,
for your
everyone.
presentation.
Appreciate it.
Appreciate it.
We're off the record for the day. Thank you.